Good morning, everyone, and welcome to the Nevada State Board of Cosmetology. The date is May 11th, 2026, and time is now 9:12. Thank you for your patience with getting started today. At this time, I'd like to do roll call from our Southern Office board members. Can we get roll call started, please?
Board Member Wold, present.
Board Member Detry, present.
Board Member O'Brien, present.
Board Member Douglas, present.
Board Member Perry, present.
Board Member Marino, we have you on mute. We didn't hear your roll call. Can you try again, please? We still can't hear you.
Board Member Moreno, present.
Awesome, thank you. All right, let's go to our Northern Office board members for roll call, please.
Board Member Jeffers, present.
Thank you. Let's jump back down to our Southern Office board staff for roll call, please.
Yes, Madam Chair. Steve McDonald, Executive Director, present.
Janie Huggins, Chief Compliance Officer, present. Lauren Gossage, Regulatory Compliance Specialist, present.
Todd Weiss, Senior Deputy Attorney General, Board Counsel, present.
Thank you. Let's go to our Northern Office for board staff roll call.
Aaron Litterer, Lead Licensing Specialist, present.
Joseph Esturnio, Division Counsel.
I'm sorry, I thought you already went. My fault. I'm going to skip over you. Okay. All right, I think that's everyone. Thank you, and welcome everyone. The mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare of those that obtain cosmetology-related services through the delivery of quality testing, licensing, inspection, and education services that focus on consumer protection. At this time, we're going to take comments from the general public for discussion only. The board will entertain comments from the general public for any item that is related to the Nevada State Board of Cosmetology. Members of the public can call into the meeting to make public comments by dialing 1-720-707-2699 and entering 897-2923-6029 for the webinar ID. The comments are limited to 3 minutes or less, and no discussion or action can be taken during public comment. Do we have any public comment at this time? No? Okay. Okay, if any if any online attendees have public comment, you can raise your hand, and then we'll allow you to have your 3 minutes. If not, we're going to move on to agenda item 3. Okay, I think we're okay. All right, so agenda item 3 is the approval of minutes from previous meeting for discussion and possible action. The board is to approve minutes from the previous board meeting. Can I have a motion, please?
This is Board Member Detry. I'd like to motion approval of the minutes from the last meeting.
Board Member Wold, second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Thank you. Okay, agenda item 4, we're moving on to our complaints, and this is a continuation from February 23rd, 2026 disciplinary hearing. Public hearing on complaint number C-2026-0018 for discussion and possible action. The board will conduct a disciplinary hearing regarding the allegations in the complaint filed on January 29, 2026 against respondent Cosmetology Institute of Las Vegas, license number SC-14500, business ID number NV201412566798. Denise Dixon, owner-operator. Upon conclusion of the hearing, possible action includes the imposition of discipline. All right. We have appearances with Joseph Piacinio, Deputy Attorney General for the board, Todd M. Weiss, Senior Deputy Attorney General, Counsel to the board, and we have Elizabeth Brennan for the respondents.
Madam Chair, do you mind if we proceed with closing arguments? Thank you. Chairs, members of the board, thank you for your time and for the work that you guys do. I will keep this short because I believe we do not need to rehash everything the board has already learned over the course of the past 2 meetings. The record is extensive, as you all know, and the pattern is clear. Before I address the evidence, I want to be clear about the standard the board has to apply here. The burden of proof is a preponderance of the evidence. That means more likely than not, essentially a 51% standard. The question is not whether every detail is proven beyond a reasonable doubt. The question is whether the evidence shows it is more likely than not a violation has occurred. This case comes down to duty and impact. Our duty is impact. Our duty is to uphold the law and protect the public. The school is allowed to operate because it holds a license from the Nevada State Board of Cosmetology, and that license comes with basic responsibilities. Those responsibilities are not optional. They include proper supervision, accurate and honest timekeeping, sanitary and safe conditions, required equipment, and most importantly, accurate student records and timely reporting so the board can verify eligibility for licensure. The evidence in this matter more than meets the preponderance standard. In fact, it far exceeds it. Although we believe and have shown multiple incidences of non-compliance with laws and regulations in just 3 student files, it is important to emphasize this point. For each violation and each count, the board only needs to find 1 instance of non-compliance. We do not have to prove the same violation happened many times in order to sustain a count. 1 proven instance is enough. But here, the board has not been shown just 1 instance. The evidence shows dozens upon dozens of instances of wrongdoing and non-compliance. Board staff have reviewed over 20 files. What is in this complaint is just a thumbnail of what has been found. These issues are systematic, repetitive, and duplicative throughout the Cosmetology Institute of Las Vegas. And they have been ongoing for years, dating back to 2015. The impact here is real and it is serious. Students paid to attend the school. They invested time, effort, and money to complete programs with the expectation that they would be able to sit for the licensing exam and earn a living through license practice. Instead, the board has repeated failures in record keeping and reporting that prevent students from testing. When records are missing, late, altered, inconsistent, or cannot be verified, the board cannot approve a student for testing. That harm does not stop at a denial letter. It forces students into an impossible position. Some students are being told they may need to return to school or repeat hours because their records cannot be verified. That means more tuition, more transportation costs, more childcare costs, and more time away from work. It means more loss of income now, and it delays the ability to earn income thereafter. It keeps people from becoming licensed and earning a living legally in this profession. The longer they are stuck, the harder it becomes to support themselves and their families. And the more likely it is they leave the industry entirely. and it is not something students can fix on their own. Students cannot enter themselves into the portal. They cannot create completions, withdrawals, or time records the board can completely rely on. They cannot correct what the school failed to submit. Students are dependent on the school to do what it is required to do. I also want to acknowledge something important. I am sympathetic to the community the school serves. The community needs opportunity, access, and schools that help students move forward. Many students choose schools like this because it feels reachable and local, and because it serves people who are trying to build a career. But that is exactly why the board must act. When the evidence shows ongoing noncompliance, if we do not enforce standards, we are not helping that community. We would be doing the community a disservice. We would be allowing more students to enroll, pay tuition, and risk ending up in the same position. Unable to test, unable to become licensed, and unable to earn a living through licensed practice because the school cannot or will not maintain reliable records and basic compliance. Accountability is not anti-community. Accountability is pro-student and pro-public. The board's role is to uphold the law and protect the public, and that includes protecting students from being harmed by a licensed school's failure to meet basic requirements. The goal is not punishment for its own sake. The goal is compliance that is real, measurable, and sustained, so students can complete training, sit for the exam, become licensed, and work legally. Based on the evidence in the record and the preponderant standard, I respectfully ask that the board find the violations supported by the evidence and to order appropriate discipline and meaningful corrective action. I would also ask the board to consider the harm to the students who paid for an education and are now blocked from licensure, facing delays, lost income, and in some cases being forced to return to school because accurate records and reporting were not provided. Thank you for your time and consideration.
Thank you. At this time, we'll go to Ms. Brennan, and you can make your closing statement.
If you could give me 1 minute.
Yeah.
Good afternoon. Good morning. Thank you all for your time and attention for this lengthy hearing. I usually, everybody talks too loud, so if you can't hear me, let me know. Good? Okay, thank you. I want to start by saying thank you all, board members, for your attention during this lengthy hearing. I know this has been a little protracted and not your everyday board meeting, and so I do appreciate, my client deeply appreciates your time, your attention, your listening, and you're going through all the evidence and listening to the testimony. And, you know, I'm here representing this beautiful lady because it matters to her. This school is her life. She's devoted to it. She's committed to it. And none of you got the opportunity to meet her on this board until this hearing. And none of you got to really hear her word until the end of the hearing. And that's fortunate in one sense because she's never been before the board before, because she hasn't had to ever in 11 years. And 11 years since her initial license and 5 renewals by the board, She's never been before you all before. So she paid a lot of money to pay me as to be here, to represent her, to fight for her students, her school, and her occupational existence. So I really appreciate your attention and the seriousness upon which she takes this case and in which you all take this case, and what we propose the solution is moving forward. Okay? Like I said in my opening, what my client really wants is what's fair and a reasonable result, that this board can apply equally to all schools that you license and all students that you test. And I think it's, that's what we want. And she's not asking for special treatment. She's taken full responsibility for some of the issues that we talked about in this hearing. But she's asking this board for what's fair and reasonable, and that she and her school be treated equally, like this board intends to treat every other school going forward and every other student that applies to test, because that's the law. And you all are very accomplished individuals. I've read a little bit about each of you, and I'm quite impressed, and I appreciate the time that you take out of your lives to participate in your individual capacities for the role that you serve. One is a cosmetologist, one is a nail, one for the public, all of that. That's very important. And I want to just start also by saying I apologize for some of this lawyer stuff that I've had to do over the last couple of days, and you know, sometimes it can be off-putting, and don't take it out on my client, please. And I'm not trying to be disrespectful. I'm not disrespecting you. I'm just trying to make the record for my client, because that's what I'm hired to do. So I apologize if I've come across a little abrupt at times, but I value your time, and I'm just doing my job. And I value these ladies' time and what they have been doing, and so just because I ask some hard questions isn't, I don't dislike them. I know they're doing their job too. It's a hard job. And, you know, when the Attorney General talks about the obligations of this board, I know you know what your obligations are, because you all have been on the board for a while. But, you know, I found it interesting in reviewing the Attorney General's manual for board members. And it talks about the Nevada Attorney General. She put it out in 2013. It remains applicable. But it talks about and explains to board members what their obligations are. And it's you know, there's been a lot of talk about what the obligation is to the public. And we know that. We want to make sure the public is safe and that the public is safety. One thing about the counts that they're asking for in here, when you look at the complaint, none of those counts have to do anything with safety. Keeping my client licensed is not a safety issue. Any citation, any compliance warning that she has ever been issued in 11 years, she rectified, she remedied, she cooperated, and it's long been done. There is no safety issue here. One of the things the Attorney General talks about in the board's obligation to the public is the public has an expectation, and I quote from this Attorney General manual, of fair dealing with the profession. Fair dealing with the profession. This school is part of the profession. Her school. And the public anticipates a fair method will be utilized in investigating complaints. That's what the Attorney General says in her manual. And one of the things that is important is the public's right to be informed about the date, the time, the location of the hearing, and to attend the hearing if they like. And that's why these boards are required to follow the Nevada open meeting laws. Unfortunately, there's been a problem with that in this case. Because the Nevada open meeting laws require 3 working days' notice, and the case law in Nevada, and the Nevada Supreme Court, the Attorney General opinions, everything make it very clear that any violation, no matter how small or seemingly irrelevant or unimportant, will void any action taken by a board. So I have great concerns that, for whatever reason, we have a public notice violation for the second day of this hearing. I'm sure it wasn't intentional. You know, people make mistakes. My client has had some mistakes in her record keeping. She is not perfect. The students, all of these students, their obligation under the law to keep those records correct. They're responsible for the harm they cause themselves as well. But you know what? We have a situation here now. We've been and spent a lot of hours, and unfortunately, any result that you render may be void. Because if we don't like it, we're going to appeal it and make sure that we take the position that it's void. So we want to reach a solution that moves forward amicably, cooperatively, and we believe that this case should be dismissed with prejudice, with no sanctions to my client, and move forward to have my client continue implementing the changes to the timekeeping regulations that she requested and she was provided by Janie on December 24th of 2025. And she never even got a chance to prove to anybody that she can do that. That's why she was so shocked with this lawsuit. But we know, based on that, we have public meeting issues, right? We do. Because Exhibit B, which is the notice for the second meeting, I printed off on my computer that morning at 12:04 a.m., and my computer showed 3 p.m. 3 p.m. You know why? Probably because I spend most of my time in Florida. So your system didn't take into account that what time zone people were on. On the other hand, but that shouldn't matter. You might have people that live in Nevada. I got a place in Nevada. I go all over, check my computer, wherever I am, and it shows 3 o'clock. A public might have planned on showing up at 3 o'clock. Then the morning of the meeting, the second meeting on March 30, 2026, I sat out in the lobby here and I screenshotted this, and it showed 12 p.m. was the start of the meeting, which is exactly what my client had told me the night before. She said, "I'll see you there at noon tomorrow." I said, no. And so that's why I brought this public meeting issue to the board's attention. It's my obligation. I want to make everybody clear. And I brought that at the beginning of the meeting, and then suddenly, right after my public comment, I checked again, and Exhibit D, I took another screenshot at 9:18, right after I made the public comment that this meeting was not publicly noticed. Someone on the staff changed it to 9 o'clock to seemingly suggest that it was never wrong. Well, that's altering the documents after the fact that give the impression they were always right. They weren't right. You can't correct them retroactively. Just like my client cannot retroactively correct student time records that are incorrect, this public notice violation can't be retroactively corrected either. So let's try to move forward and resolve things amicably today so that that doesn't have to become an issue in any future court hearing. One of the other things that the Attorney General talks about in this manual about board obligations is the obligation of the board to the potential licensees, whether they're individuals or schools. So I haven't heard that expressed from the other side in this hearing. But make no mistake that the Attorney General's office clearly says that you guys have an obligation to the licensees and potential licensees. And what is that obligation? It's that a person who wishes to earn his or her living in an occupation that requires licensure should not be kept out unreasonably. Once again, it gets back to fairness. My client should not be unreasonably denied or revoked her license. Her students should not be unreasonably denied or revoked their license. We're asking this board to be fair to my client's school on equal footing with every other school, to be fair to my client's students who are testing and all other schools, because that's the law. Why is that the law? It's the law because we have the Constitution. We have the Constitution of the United States and we have the Constitution of Nevada that provides for due process and equal protection to everyone. And part of that legal obligation to comply with the Constitution is to construe regulations consistently, fairly, equally. Not just to one school, but every school. Not just to one licensee, but every licensee. The board cannot act arbitrarily against just my school that unfortunately appears to be a target. The board can't discriminate just against my client's students or my client's school. They have to be treated in a standardized, equal fashion. And that's all we're asking for, and that's not what we've been getting. And I'll summarize and explain that in a minute. My client has a liberty interest that's guaranteed by the Constitution to pursue her occupation of her choice. Like groups are entitled to be treated the same. It's called equal protection under the laws. You can't take one group and treat that group differently. You can't take one school and treat it differently than other schools. That would be against our Constitution, and that would be against the board's obligations to construe the laws consistently for everyone. And that's all we're asking for. Like I said a minute ago, nobody's perfect. People make mistakes. There were mistakes made in the everybody makes mistakes, so we cannot expect perfection from anybody, and I don't think that's the standard. What we have in this complaint is basically two categories of issues. Two categories. One category is the resolved issues. That's category one. The resolved issues that frankly should never have been brought in a complaint. They haven't been brought in a complaint against any other school for resolved issues. The resolved issues consist of the citations that my client has received over the last 11 years, all of which have been paid, all of which have been rectified, long before this complaint in 2026 was ever filed. All of these compliance reviews that my client ever got over the last 11 years, she took the corrective action, she cooperated, and resolved them. Then. So the staff testified that Ms. Dixon has always been cooperative over the last 11 years and continues to this day to be cooperative. So we have citations and compliance reviews that were all resolved issues. They're all in category one. And then we have some random issues. They're part of category one. They were never important enough for the board doing their job to issue a citation or a compliance warning. Well, if they weren't important enough to issue a compliance warning or citation in 2023 or 2021 or 2024, but they just were the subject of an email or a letter that went to my client or a bunch of clients, a bunch of schools, they're resolved a long time ago. The distance learning issue that all the schools were confused about years ago, that was long resolved. Why were we even talking about it, wasting our time? The grandfathering for advanced aesthetics, there was confusion about that amongst all schools as to who could take that test and who could get taught that, which is why they had to have a board meeting and have the email issued explaining that to all the schools. Not just my client. Why are we talking about that? It was resolved back 10 years ago. So we have category 1, which are resolved issues, citations, compliance reviews, or miscellaneous issues that didn't even rise to the concern of the board or the staff for years. But now we're here to talk about them? No. No other school in the history of Nevada, in the history of this board, has ever had a complaint filed against them requesting that their license be revoked when they have been cooperative and handled and resolved every single issue the staff ever asked them to handle. Never. This would be the first time if you revoke her license or if you put her on probation or something for issues, all of which were in category 1, that have been long resolved. I have looked through the minutes of all these board meetings. There are no other complaints that has any school being brought down for this. That is not equal treatment under the law. That is not fairness. When somebody thinks they're cooperating and they resolve it, they should know that it's resolved. I mean, that's like saying you have a driver's license, you just went out and bought a new BMW, and you got 3 tickets 8 to 10 years ago that you paid and fully resolved, and now all of a sudden the driver's license bureau says, you know what, we're revoking your license. Forget about the BMW, you can't drive it. You already paid for that. No, they want you to double, triple, quadruple fine my client for citations she's already paid or issues that didn't even rise to that level. I respectfully submit that with respect to category number 1, all these unresolved issues, frivolous, should never have been brought. Not unless they intend to consume all of your time and have a boatload of other lawsuits filed against all these other schools that are on your website, then it's not fair. It's not equal treatment. It's not constitutional. And I submit, I don't know why this lawsuit was filed, honestly. When we started in opening, I said we were shocked. My client was shocked because, you know, she is the one that when this record-keeping issue came to light, she is the one who requested training. She requested training. This record-keeping issue first came to light in, October of 2025. So we have 2 categories. We have the category 1, which are all the resolved issues that should never have been in this lawsuit, and then we have category 2, which are the record-keeping issues. Now, I'm going to talk about the record-keeping issues in a minute, but I respectfully submit that the resolved issues in category 1, which they spent a lot of time on, was simply to try to pollute the judges. You guys are the judges. To try to make you not like my client. To try to make you think that she has some kind of issues or problems that are systemic and not resolvable. That is not true. Just because an attorney says something in his closing statement doesn't make it a fact. There are no systemic safety and health issues. There are none of these issues. Any issue has been long resolved regarding those issues. one of the things I think is important to point out is, talking about category 1, which is the citations, my client, over the span of 11 years, only had citations totaling $1,400. You break that down over 11 years, it's basically $127 a year. $127 a year in citations. Does that sound like somebody with a systematic problem? When I look at your board meetings and I see the financials that you guys just reviewed and approved at one of the most recent meetings, I see that in your income statement you show citation fines that you received in November of 2025, $89,700 for the month. Your year-to-date total in November of 2025 was $395,450. But your budget for fines was $417,800. So this board generates income off of fines to licensees, which include individuals and entities, and to the tune of $400,000 a year. My client's fines are averaged to $127 a year. Now, if somebody with $127 a year average is going to get their license revoked, where are the complaints against all the other people that come up that make your $400,000? Why aren't they before their board for revocation, whether it's a school or an individual? My client's average is $127 a year. You've got $400,000. So if there's going to be fair and equal treatment, you're going to be having a hearing every day, and you're going to have no licensees if you revoke my client's license, because we insist on fair and equal treatment. And those other four, I'd like to know why they're not here, why they don't have a complaint filed, why their license isn't being requested to be revoked. So obviously, there's a problem, and my client is not the only one. She should not be targeted, discriminated against, arbitrarily picked out to be made an example of. No. Let's not make her an example. Let's make this case a solution. A solution that says, this is how we're going to deal with these record-keeping problems going forward. Okay? Because when we focus on what this case really is, or should only have been about, is the record-keeping category. Okay? My client and this board and this staff for 10 years and 10 and a half years never recognized that there was a problem. Okay? So, you know what? Initial licenses and 5 approvals. Maybe everybody should take some accountability together, because I think we kind of got here together. I think that all that was required was the certificate. And you know, it's interesting because the testimony was always, from everybody, was very consistent, that the only thing that the schools had to provide was the transcripts, their certificate of graduation, you know, and that's all that's been required. And you know what's interesting? That's still all that is required, because this staff sent out an email to all schools on April 29th, 2026, telling all the schools, this is to notify and update you to the testing application document requirements. And it says every school needs to know that all they need to do is provide the following: driver's license or state ID or passport, social security card, photo for licensee, name change documents, completion of 10th grade, and beauty school transcript or student employer release. That is it. That is the law. That is what you are requiring of all schools. Oh, no, except for mine. Except for mine. All schools are required to be treated the same. And the issue is that when the staff went in there and my client turned over the student files, they reviewed them, and there are discrepancies. There are clearly issues to that. Did everyone here listen to all of her testimony? I hope so. Because she was beautiful witness. She took full accountability. She showed that she cooperated all these years and continued to cooperate. And the fact of the matter is, this board does not know what issues you have with all these other schools out there. Why? Because you haven't done the audit like the IRS audit that you did of my client. So, are we going to have a double standard? The kids that go to school in North Las Vegas, they get more requirements than the kids that go to school in Summerlin? Is that how the governor wants this thing run? Every school has to be treated the same. And part of the problem is that the cosmetology board and staff don't really have standard forms or procedures for the student curriculum record keeping part of it. And that became painfully clear when these young ladies had to go through what they did. That's painful. Why doesn't this board, this staff, you've got this brilliant executive director with 1,000,000 degrees, he's an MBA, law degree, everything. This is the perfect opportunity to use this man's expertise and training to have this board come up with some standardized forms to help the staff, the board, the students, the public, the schools, everyone have smooth sailing, safety, standardization, make it easier for everybody. The real estate board, you got all these standard forms. You want to buy a house, you want to buy something, you use this standard form. You don't have a lot of options. You got to use these forms. Contractors board, same thing. Contractors board, the same thing. So this is a perfect opportunity. We're talking about solutions. I know in the beginning of this, Molly said, so what would be some solutions? One of the solutions I propose is use this brilliant man's expertise and his smart staff who have to deal with these audit issues to come up with a standardized form, a standardized procedure that every school has to use. They would know best. Okay, it shouldn't have, I mean, there are apps, there's whatever. I'm not an expert at this, but I know they are. And then you have uniformity. Then the staff's time is not wasted on doing audits. The system runs itself. And then the forms are identical. And we can see that every school is doing it the same. I mean, one of the big things that I have a problem with is that these performance sheets the curriculum sheets that my client had been using, they're not even required by statute. The law is very clear that the students have to keep their curriculum sheets. That's the student's obligation. And the law is also clear that the final time record is kept by the school. And that's what they did. But you've got to have some standardization. One of the things I've learned is that a lot of schools don't even keep their curriculum hours. So instead of having the students clock in exactly how long they did haircut 1, haircut 2, haircut 3, haircut 4, some schools don't do that. They say you need to do 10 short haircuts, 10 long haircuts, 1 male manicure, 1 pedicure. What? Who says that completes the number of hours? I mean, based on what I hear, this staff and board wants exact hours. They got to match up perfectly. Well, who says that I do 10 haircuts in the same time that you do 10 haircuts? Maybe I'm quick and cut corners. Then that person hasn't gotten their enough hours. Why is the board of some school to satisfy their testing requirements with that system that does not track their exact hours? My client's system at least is making some attempt to actually track the hours that they're doing it. You know, unfortunately, Nevada, when it comes to education, is kind of last in the country. I think that what I saw recently was that of graduating high school students, I think only 34% are proficient in math. So we're having these people that might not be proficient in math, that can't go to college because they don't have the money or the resources to do so. They decide to go to trade school, and now they've messed up their performance timesheets. Okay? I think one thing is clear from my client's testimony, all the staff's testimony, and every one of the individuals that you saw in these individual board hearings regarding testing. No one is intentionally misrepresenting their hours. No one is intentionally, fraudulently doing anything. These kids were doing the best they could. They got it all botched up. Nobody's paying attention, clearly. The staff wasn't concerned. My client thought it was all in order. And the first time it came to light was in October, November, December of 2025 when the staff got on it, my client got on it. She had training. She trained her staff. She requested training. She requested specific details about what she could do to get these record-keeping issues in line. She implemented brand new, she updated all her procedures, manuals, and operations. She updated all her form. She implemented all of these things. She hired new staff. Of course, we know the old registrar unfortunately passed away a week before this hearing. I don't know what the cause of her death was, but hopefully it wasn't because of stress of having to come testify to all this stuff. We need to have a better system. We need a better system. I don't think I think these ladies are too smart to have to use their time trying to decipher these mathematical things, that some brilliant people should be able to come up with a form or a solution that's uniform. You know, in order to revoke somebody's license, they need to be doing something intentional, something fraudulent. That's not here. Those facts are not here. There's nothing illegal going on. There's no prostitution going on. There is nothing fraudulent going on. There are full cooperation. So, are we going to just shut down every school in the state of Nevada and stop allowing in every student to test? Because last I checked, you're not requiring every school to produce their client entire files and backup documents. And that is a violation of those, my client students' constitutional rights. Some of them may start lawyering up, and then that'll be another issue. Let's solve the problem, not create litigation. Solve the problem by having this unfortunate situation. Let's not point fingers. Let's try to all cooperate like everybody has been. Let's reach a solution and move forward collaboratively. And make it can be a wake-up call to all the schools. Look, the board's got some new standards, some new rules. Everybody has to provide all their backup files. And if they're not exactly 100% perfect, then all your hours are going to get canned. And you're going to have to retake it. And let's see what these other schools think about that. Because, for example, the unequal treatment and the discrimination and the violation of my client's constitutional rights are significant. I'm going to give you one example, though. These students of my client that have applied to test for their nail license, okay? They're coming before you all, and of course, you're requesting their backup performance sheets that they created. So when we talk about a harm to the students, there needs to be some accountability for their own actions or failures. They created those performance sheets, not my client. The law says very specifically it's the student's obligation to keep their curriculum sheets. And so I have her nail student that wants to test. She comes in to the board and they look at all her backup paperwork that they don't look at for any other school, and they say, well, because my school has a nail instructor and like a cosmetology instructor. And I think you all know that a cosmetology instructor is licensed to teach nails. A nail instructor is also licensed to teach nails. Many schools don't even have nail instructors. They just use cosmetology instructors to teach their nail students. And this board has no problem licensing those nail students based on a sign-off of their hours by the cosmetology instructor. In contrast to my client and her students, they are being denied the right to test, and their hours are being stricken because they were signed off on by this school's cosmetology instructor instead of the nail instructor. My client testified that on Saturdays, her nail-specific instructor is not there, and that all nail instruction on Saturdays is done by the cosmetology instructor, which she is licensed to do. Despite that clear right, this staff has recommended and this board is adopting deleting all these students' hours? Why? That's not right. That's not fair. That's unconstitutional. My client serves a valuable role in this community. The public comments from the people that showed up at the first hearing, and the public comments were beautiful. They loved her. They felt like she and her school were more than just a school. They provided a lot of love and hope to their families. And of course, maybe some more public comments would have taken place on the second day, but of course it wasn't noticed properly. So we don't have the benefit of those comments. But what we do know is that my client has won a lot of awards. She's Exhibit A showed that she got the Small Business of the Year award by the Urban Chamber of Commerce in 2019. She got the Bronze Best Trade School and Technical School by the Review Journal. That's people voting for her. This wasn't awarded to some big corporate school. It was awarding to her. She got an award again in 2022 by the Nevada Business Award, sponsored by the Nevada State Bar Association. Small but mighty, one of the leading businesses. We're going to revoke that license for record-keeping issues that the staff and the board and my client were unaware of for these years, that the only way to correct is going forward. Unfortunately, we are where we are. So what I kind of think is maybe we need to have a little grace with some of these students and give them the benefit of the doubt on some of this, not be writing off all these Saturday hours. If their math doesn't completely add up, where we're just deleting it all, maybe we need to have a little grace. Let's get through this. My client has already implemented all the new procedures and policies that the staff has wanted, that she got on December 24th, which were mostly implemented before she even got served with this lawsuit. That Exhibit 30 is the December 24th email from Janie Huggins that says, "Good afternoon, Denise. Please see attached suggestions and guidance as requested to get the school on proper footing moving forward." As requested. My client had been requesting training, guidance, details the minute she found out about this issue. And she's been proactive. She's made those changes. I respectfully submit their burden of proof has not been met. It has not been met to revoke someone's license. There's no fraud. There's nothing there's nothing that rises to the level of revoking somebody's license. The record is clear. She has never received a citation for these time record keeping issues, ever. Is that the standard that this board is going to apply equally to every school? If you find record-keeping violations for 3 students, or any student, anyone, you're going to revoke their license? Is that the new standard in Nevada? Well, we're not going to have any schools. We're not going to have any schools. But what happens to my client needs to happen to all clients. Well, they might be my future clients, but it needs to be done uniformly. And when a record-keeping, these time-keeping violations have come to a school's attention, then the solution is give them a citation, give them a corrective notice, give them an opportunity to fix it. Don't just file a complaint and try to throw them out of business. That doesn't help anybody. That does not help anybody. And from what I understand, she's doing just great with all this. And another thing, these portal issues, getting the students enrolled in 30 days, the testimony is consistent. This is a problem that the staff has with all schools, which is why they sent this letter out saying we're going to start fining all of you, okay? Because they testified it's all these schools. Now, is there a complaint pending or in the cooker to revoke those other schools' licenses? Because if not, it's not equal treatment. The culture at my client is to cooperate and correct. And that's what she's done, and that's what she's proven. Some of these issues that they want to recommend a fine for, they're isolated issues. Okay? There is no record here of my client's students habitually not being on premise during school hours. That is not the record. To the contrary, the record shows that for 11 years, all they have is 2 students that couldn't be accounted for. In 11 years. You're going to revoke somebody's license because of that? The student was reprimanded and the hours deducted when they left. And you heard the testimony of my client, the most recent one. The poor young lady had her period bleed out all over her clothes and she ran out. I'm sure women can understand that. That doesn't make it right, but like nobody knew she was even gone. And then she came back and it got corrected. But this is not a habitual issue. You don't revoke somebody's license because 2 students in 11 years couldn't be found on property. My client uses the state-of-the-art finger biometric system for clocking in and out to satisfy her obligations under the regulations and statutes. And when she's been using that since she started. She was applauded by the board for being one of the first schools to implement it. And you know what? That's record proof. You know, my fingerprint is different than yours. So you got to actually walk physically in the building, put it on, and when you leave, put it on. Okay? And that is the official records. She's always kept them. She has those on premises, and she's provided them to the staff. And she has always cooperated. There's no lack of cooperation. She never provided false information to this board either. She's always provided whatever she had. She doesn't have a habitual issue in not having an instructor there. I think there's one time there was an instructor that was running late. Tell me that doesn't happen at any other school? That doesn't happen? An instructor never comes in late? I bet it does. And what did she do? And she had a provisional instructor there as well that unfortunately the paperwork hadn't been processed to switch her from one school to the other. You're going to throw somebody out of business for that? Revoke their license? She resubmitted the paperwork that Saturday. That instructor, her license was provisionally licensed and up and running at this school by Tuesday. It's not like you have somebody that doesn't know what they're doing training, and she didn't even train that day because they closed the school down because they didn't have enough instructors on that one day. Because Janie had said everybody needs to leave, which was fine, and that's what they're supposed to do. That's what Janie said. That's what you're supposed to do. So this happens one time in 11 years, and you're going to revoke her license or put her on probation? I don't think so. You're not doing it to other schools. Boot camp. She provided one boot camp years ago trying to help underprivileged kids in the community. And she gave whatever paperwork she had, which was the flyer. She didn't think she was doing anything wrong, and neither did anybody else, obviously. And when it came to her attention, she didn't even know who this person was because they weren't a student. They were in that boot camp. And once it came to her attention and they figured it out, she provided the flyer, she provided her company information, and that's it. And Janie and them said, you know, don't do it again. If you do, let us know so we can, like, come up with some rules. She said, fine. So why are we here talking about that? Trying to help some kids in the community? Nobody was harmed. That happened years ago. It's just trying to stir the pot. Are we trying to stir the pot here and throw this lady out of business, or are we trying to solve a problem and help everybody? Because I think we should be solving the problem for everybody. And that's keep her license, let her keep running this, provide these updated procedures to the staff, and if they want further revisions, she can work with them. But you got to have time to implement and change this. And it needs to be uniform to every school, not just mine, clients. There was all that testimony around about the laser being locked up in the room when they came for inspection. What did we discover? We discovered that the law doesn't require the laser equipment to be out in the room when that's not being taught. It doesn't require it to be, it just requires it to be on the premises. on the property, on the school, so that it can be used by the instructors when they are instructing on the use of the laser equipment, which is exactly what my client did. There's no testimony or evidence that my client's students aren't properly trained in the laser equipment. And since the staff wanted it taken out of the room, it is now to be broken by whoever accidentally breaks it. Those equipment is every time she goes to repair, it's $3,400 each. She got 4. So you want it out, it's out. Okay? I think one thing that's important too, when we talk about, is there harm to the public? Is there harm to the students? No. The harm is that nobody caught this record-keeping stuff earlier, and we all bear some responsibility because it's been going on for years. And I respectfully submit that if we subpoena all these other school records, they're going to have the same issue. My client isn't the only school that has this issue. And it's, the students have to learn how to do the paperwork too. But, what I'm saying is, my client's school is, in fact, teaching the curriculum. All of her students that are allowed to take the test, they're taking the test, they're passing the test, they're being licensees, and there's no testimony or evidence that her students have any higher rate of failure. There's no testimony or evidence that they're not successful licensees in this state. So these students are learning. These students, the testimony of all the students that I've listened to at those hearings are saying, we were there, my client says they were there. So their paperwork's not exact, but the harm is the board harming them by not letting them take it because the paperwork's not perfect. What is perfect is the biometric time clock. That shows that they're there. I mean, these other schools, you're not even requiring them to prove that the kids are on the premise. You're allowing other schools a different timekeeping system. You're allowing them to use an app to check in when they're in the parking lot or at the Target next door. Why is that okay? Why is that better than, why aren't those schools being called up? Because they're sitting in the car, perhaps smoking a cigarette, perhaps talking to their boyfriend, perhaps doing whatever, I don't know. But they certainly aren't in the classroom learning about whatever they're there to learn, because you can't learn it from the parking lot. Distance learning ended a long time ago. So in summary, my client just wants what's fair and equal treatment, and that means dismissal of this complaint. With each party to bear their own attorney's fees and costs, by the way. The statute is very clear that the board has no authority to issue attorney's fees or costs against the other side unless the detailed invoice has been provided to me and my client. And despite repeated requests, which I don't have to request, but if they want to recover their attorney's fees and costs, that's what the law says they have to do. Let me get this here for you. It's in their complaint. I think it's page 19 of the complaint, cites NRS 622.400. And it says recovery of attorney's fees and costs incurred by regulatory body in certain regulatory proceedings. And it says in number 2, a regulatory body may not recover any attorney's fees and costs pursuant to subsection 1 from a person who was the subject of an investigative, administrative, or disciplinary proceeding of the regulatory body unless the regulatory body submits an itemized statement of the fees and costs to this person. I requested that repeatedly when the trial was open. The trial is now closed. The time for evidence has ended, and the case is over. They never submitted it. They're not entitled to it. The board has no authority to grant attorney's fees or costs. Furthermore, the board really, based on the testimony and evidence, it would be reversible error for this board to accept as findings of fact and conclusions of law the allegations in the complaint, because you've just heard all the testimony and you've seen the evidence, and significant portions of that have been completely refuted. So those findings of fact and conclusions of law would not be consistent with the testimony and evidence in this case, which is what what you all are required to do. The complaint are just allegations. The testimony and exhibits are what the board is supposed to base their decision on. And so the solution here is for the board to deny the complaint. Somebody needs to move to dismiss the complaint with prejudice, with no action being taken. And that is what we are requesting. My client shouldn't be put on probation. She's doing what they ask her to do, just like all the other schools are doing. They're not on probation. Let her have a chance. Let her have a chance. And then, one more thing. These counts, I'm a little surprised because I guess they're not going to recommend anything because they didn't make any recommendations. And so other than what's in the complaint, because, my client should have the opportunity to respond to whatever recommendations they're going to make. He didn't make any recommendations in his closing. He just said, recommend you do what you want to do. So what I'm going to say is the recommendations that they have in the complaint, they have 13 counts, and none of them have to do with safety issues, not one. If you want to take a look at them, they have to do with record keeping, which is the issue that we're here to talk about. So I appreciate your time, and I respectfully submit that dismissing this case, letting my client go on and proceed with her business and show you how it can be done. Thank you so much.
Thank you.
May I take 10?
Yeah.
That was kind of a long-
Well, before we do, can I set the record straight on some points of law that were misconstrued?
Yes.
Okay. So, a couple of things. I just want to put this out there. Council said that there is an intent requirement for NRS 644A 850. She didn't quote the statute, but she says that you cannot revoke or suspend a license without intent. That is not required in the statute at all. Public comment does not factor into your decision making, just to make that clear. And then the OML issue, may I address that, Counselor, or do you want to address that?
Jack Todd Weiss, it's already been addressed on the record. I mean, we heard again, that's fine, but that issue was addressed at the last meeting. I don't see a need or point to address it with the board or council again. We determined that the notice that was served on council and respondents had the proper time on it, whether there was a temporary glitch on the website or what have you, had no impact on their knowledge of when this proceeding started. And council confirmed that no witnesses were unavailable as a result of a potential technical glitch. So that's why we determined the OML issue did not pose any sort of due process injustice that required us to continue the meeting from the last hearing. Again, that was already addressed on the record with the board, with council. We don't need to go into that again. But I just want to say that since that was brought up again during closing. Thank you.
Thank you, Madam Chair.
Board Member O'Brien, before we take a break, I do have a question regarding something that was stated at closing statements, and this is for our attorney. There was a statement stated that Attorney Brennan made to seem pretty factual regarding attorney's fees. Can we get clarification on that statement, please? As we've never really heard of that before.
I want to look into that during the
Okay.
break, so I hold that question,
Okay,
and I will
perfect.
address it when we come back on the record.
Okay. All right, guys, let's take a break. It is 10:27. Let's round up to 10:30 and be back here at 10:40. Okay? Thanks, everyone. All right, everyone, welcome back. The time is 10:47 on May 11th, 2026. We are going to get started again with our disciplinary hearing for CILV. We have now finished closing statements, and we're going to jump into our deliberation as a board. Board members online, are they able to interject as they have everything? They don't need to raise their hand or anything. Okay, perfect. So you guys have all been given the ability to chat freely, so this will be just as if you're in the room with us, okay?
And Madam Chair, before we do that, I want to go back to the question about
great, yeah, thank you.
400, since that was brought up. So council respondent is not wrong on what that says and requires. Oh, sorry. Yes, which I'll just start from the top. Since that was brought up before we went to break, I want to answer that question that was brought to me by Madam Chair. Council respondent is not wrong about what 622-400 requires. So given that there hasn't been a billing, itemized billing provided to this point, what I would recommend is that the board defer that decision on fees and costs to the next meeting. Everything else we can adjudicate and rule on today, and then leave that part. We'll actually order council for the board to provide that itemized billing at the next regularly scheduled meeting, and that will give an opportunity to get that over to respondents council, and we can have a very brief agenda item at the next meeting where that billing can be reviewed. Council for respondent can make any objections about that billing that she may want to do, and then the board can make a separate ruling on a fine for attorneys' fees and costs at that time. That they'll, separate from what we're going to do today, because they're separate issues. So I'm going to let both councils state their position on that, because I'm sure there's opinions. But that would be my advice on how to deal with that, so that that there's fair opportunity for both sides to review and weigh in on the itemized billing as required by 622-400.
Okay, thank you. At this time, we'll go ahead and hear from Joseph.
Joseph Osturnio for the record. I mean, I'm not crazy about that. I'm not crazy about that rule, but I think the law allows for us to submit it after the fact, but I understand where council is coming from, and we're willing to abide by that. Yeah.
Okay. All right. Council?
I'm a little confused as to what he just said. You're willing to abide by the fact that you're not going to request attorney's fees, or you want to do what A.G. Weiss suggested? What are you saying?
So Joseph Osturnio for the record. I don't think the law intended for us not to be able to recover attorney's fees by not serving it on the day of the final hearing. I think that's crazy. Like, we don't even know what her bill is going to be. We don't know about board's time. There's a lot of costs that have to be factored after the fact. Like, we don't know how long we're going to go today unless we capped closing statements. So that I just don't think the law meant to handcuff the board from recovering attorney's fees because you don't have the statement today. But I'm this. Council, my position, or as division counsel today, we're willing to abide by what the board council has put forward, and decide it later.
Okay, thank you for your clarification. For my position on it, we object to that. That is in clear violation of the Nevada Administrative Rules of Procedure. That is in clear violation of Nevada law. NRS 622.400 clearly states that they may not recover their attorney's fees, any attorney's fees and cost, unless they submitted to me an itemized statement of the fees and cost. The day for that would have been prior to closing. The evidence has concluded in this case. Okay? And
Brian, I'm so sorry. I'm not meaning to interrupt you. The time for that, is that part of the statute as well?
No. The statute doesn't set a time limit on it.
Okay, so I think that's where the confusion is.
Right.
So that's what we're kind of trying to figure out. So there's not actually a time that is put on that?
Right.
There's not.
Okay.
And what exactly, and what I'm saying is that I object to that AG's interpretation of it. It doesn't say you can submit it a week later, a month later, whatever. The case is concluding today. You're issuing your findings of fact, conclusions, and decision today, and the case is concluded today. I mean, with all due respect to the Attorney General, I have been asking for this and did not get this. And so, you know, I hear what he's saying, maybe he needed some additional ones for later, but there's allegedly been a lot of work done that he wanted to seek, that he could have had his bill prior to today to submit on all the costs that incurred except for today, for example. And he didn't do that. And I feel like it's a violation of the rules and the statute. And so I guess if you award attorney's fees or costs, will be in court. So, because
Board Member O'Brien.
we object to that.
Sorry, I didn't mean to interrupt. Board Member O'Brien, question. A complete bill would not have been able to be provided today, correct?
I could have probably provided the billing from everything up until today.
Okay.
Yeah. So we could take a break and I could get in touch with our billing and have it done. But I think what she's saying is that I had to put it in the record prior to today. And that is not typical even in civil practice.
It most definitely is.
It is not. I just filed a motion for attorney's fees. You submit it in the final order once the judge has agreed to who's getting the attorney's fees.
I've been a civil litigator for 36 years. I'm licensed in 3 states, and I can tell you that if this board wants to rule in the future date on attorney's fees and costs, 1, I object. 2, I'm entitled to a hearing and put our position on the record and cross-examine on that. I'm entitled to, my client is entitled to due process, and my client is entitled to put a witness on the stand, cross-examine, and question about it. So if we're going to, yes, well,
No,
that was my position.
hold on. For attorney's fees and costs, counsel. No,
Yes,
there's no cross-examination for attorney's fees and costs allowed. That has never happened in the history of this state.
Okay, well, I disagree.
You can state your objection to the fees and costs, and you can state why you don't think the fees and costs were reasonable, necessarily actually incurred. That is 100% your right. But there is no witnesses, there is no testimony given
Well,
on fees and costs.
I disagree with you, so we'll just have to agree to disagree.
Okay.
Okay.
No, that'll be a part of the order. Yeah, that's at the very end. You're okay. You're good.
Yeah, you can proceed to
Okay, so at this
Deliberation.
time, we're going to go ahead with deliberation. And this is the time where board members will discuss everything, talks amongst ourselves. If and when we have questions, we can ask them. But I do want to remind everyone in the room that this conversation is between board members, so there's no comments that are going to be interjected from anybody that's not a board member at this time, okay? All right, so let's go ahead and get started. Does anyone want to start?
Board Member Wood, for the record, good morning, still morning to all the people online and the people watching. I just want to state before I get started that nobody is like joyfully wanting to cause any hardship on anybody. However, we do have a duty to protect the public, and some of my concerns since this hearing has started is that I feel like there's been a lot of lack of accountability. One thing I really did not appreciate is the constant remarks about other schools and the lack of focus on this school. And I feel that there's a gap of understanding of, like, hey, you know what, we made a mistake. There was no coming to the board like, you know what, this is pretty bad. We want to be accountable. We want to get in compliance. what is more can we do? And I also feel like there's a lot of substantial evidence over several years that is pretty relevant to this school. And I really liked what Joseph said, saying real, measurable, and sustained for the school. And I feel that the school hasn't been able to sustain positive record keeping. It hasn't been able to sustain their staff to be present, and when the staff is present, when inspectors go, they can't get clear verification of who is who. And so I just have a lot of concerns that if we were to keep the school open, that there wouldn't be any real discourse, and that we would probably, there could be retraction, and that the reason why we're saying we're going to make these changes is because we're in the hot seat today. And so I would just, my only concern is if not implementing a certain level of discipline, we're going to have this same issue again, and our awesome staff would have to go through great lengths to try to get the school in compliance. So that is my current thing. I feel that respectfully, that the defendant, the response was tone deaf to me. I'm a nurse, and for you to say that there's no harm to the public, to me is asinine. I don't know how familiar you are with cosmetology, but people not being trained is a safety standard. If I wasn't trained and I was your nurse, that would be a safety issue. You can cause people to get herpes. There's been people who've gotten HIV from cosmetological establishments. I don't know if you've ever seen a laser burn. They're pretty gnarly and can cause great damage to the skin. I've seen people's entire faces get, messed up. So I just feel that there's a lot of tone deaf, and I feel that there is no accountability here. Denise, we did talk a little bit the last time I did, and there was some accountability, but also it's just like saying that no fraud and all this stuff. There was a lot of justification in the testimony, and the last time I asked you if you were letting people know, like, hey, you can sign up with my school, but just be aware, like, there is, a chance, something could happen. I feel like that's a lack of transparency in a school that doesn't accept student aid. As a student, I would feel like I was misled, misguided, especially when, the last meeting people are coming to us wanting to get their license. And so I just feel like, unfortunately, the students have been harmed regardless, and my goal is to not see any more students get harmed, and for you guys to get into compliance, whether that happens today or if whatever we decide. But I think that's where I'm at, is I just want to see the school get in compliance, and whether you guys have to take a break to figure it out, yeah, that's kind of where I'm at with that.
Thank you. Board Member O'Brien, yeah, I think that you spoke to some of the things that we were seeing and hearing and feeling, and we are experts in our own fields, or considered to be on this field or on this board. So, we are privy to past hearings and situations that are going on and ongoing and that have happened in the past, right? So, the assumption that other schools are not held to the same standard is just wrong, and it was very hard to continue to hear some of the things that were just not accurate being said over and over and over again. And the idea that because it was okay in the past, it doesn't have any relevance today or should be held accountable. Especially knowing that our ED, Stephen McDonald, one of the huge reasons that we brought him in and that we fought so hard to have him in this position was to get these schools under control because of all of the citations and violations that were happening in salons and other places, and knowing that that starts on a school level, that is what makes the most sense, is to get these schools into compliance in a way that they set the tone and the standard for leadership and how things are supposed to be run and done. And I agree, misunderstanding harm definitely showed its head in this case so far. Miskeeping with bookkeeping is huge because, did the students do the hours, did they not, and whether the document was required by statute or regulation, it doesn't matter because it was a document that the school required, and that's what we were using to go off of those bookkeeping issues to try to line up. And, Bertha did, I couldn't even count how many hours that she did trying to put and line up and help those students find the hours that we could be like, yes, this did happen. Yes, we can grant this letter of credit. Yes, this is what we can give you. And I just think that because of this whole thing going on, it kind of maybe did feel like, oh gosh, I'm under attack, but in reality, the board has been and was trying to find every ounce of our time, leniency to help the situation until they couldn't, and then it was brought before us because the staff cannot issue citations for bookkeeping. That's out of their scope. That's our scope. That's what we're here for. We have to sit down and say, is this something that we're okay with doing? Is this okay to be like, okay, they made a mistake, they set new standards, they're going forward, we're going to give all these students a big break and tell them, yes, those Saturday hours can count. I'm sorry, we can't do that as precedent. That is a bigger deal than we see today at this one school. We are going to have a field day with that. But I do want to, for the record, just put it out there that this is a new beginning. This is a new board staff mission to ensure that these schools are having great bookkeeping policies and standards of practice, in addition to everything else. But it did need to come up that there was some issues here, and it's not just because board staff was like, there's an issue, it's because students were now being denied testing. And when you have people coming to us saying, I was there, I was doing this, but we can't account for that. That is where, it becomes kind of like, well, we have a duty to make the right decision and do something about this. And that is what our decision and deliberation today will be about. What are we going to do about this? How are we going to prevent this from happening in the future? What precedent are we willing to set today? And, what are our feelings on revocation, probation, suspension, fines, all of those things. So we have kind of a lot of hours to go off of and data. So we can kind of strum through that one at a time. We can do that all as one lump sum. But I do want for the record to know that it was not one item. It was not, oh my gosh, I'm blanking. The CRs. Corrective action. No, the something reviews. The compliance reviews. Thank you. It was not the compliance reviews. It was not just the timekeeping. It was not just the Instagram situation that led to us finding out about the boot camp. It was not just that the PIL was not filed correctly. It was not just that 2 students were found not on campus. It was not just that on campus, sorry. It was not just that hours and students' names were input incorrectly. It was all of it. It was a combination of everything that said this school needs help, but we're at our kind of limit on how to do that. So we just, I want that to be on the record because this is not discriminatory. In my mind, seeing all of those corrective actions with no fines implied goes to show just how much the board was willing to work with the school to be like, hey, we see you. We know this is hard to keep a school up and running and have all these things going on. Fix these issues, no big deal. We're just bringing it to your attention. I mean, they could have obviously went in there and been like, fine, 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 fine. And that would have been for every single, occurrence. And it really would have racked up those monetary fines that she had to pay. So I just think that there was a little bit of some misunderstanding and just tone deafness. I agree. And I do feel like all of this brought to us individually as one point. Yeah, no, it's not an issue. We can totally get that into, compliance and help with that. But when you put all of this together, this is an indication that the school probably needs a little bit more help. And how do we do that? It is not the board staff's responsibility to teach a school how to run a school. Absolutely not. We cannot do that. We cannot ask our staff to do that. It is the board staff's responsibility to ensure that that school is being run in a way that it complies with the statutes and regulations. It also is imperative that if regulations and statutes are changed or things are amended, it is not the board's responsibility to ensure that everybody is aware of those or, staying into compliance with that. That is the school's, just as it is our licensees' responsibility to stay into compliance with updates and changes. Now, they do a great job of communicating via email and posting when things go into legislation to update and change. But at the end of the day, it is the responsibility of the licensee, whether that is an individual practitioner, a salon, or a school, to be in compliance with what the current law is. And once again, ignorance of the law does not mean that you get a free pass. And just because it was okay in the past or wasn't caught in the past does not mean that it is okay and should be wiped under the rug because it's been 11 years. I don't think that a complete wipe of this case is fair to any other school in this state or just. I do think that some type of discipline does need to be imposed. But again, that discipline should be what leads the school to be in compliance, to continue to serve the community, if it is able to do so. But we need to be ensured that it is able to do so first and foremost. We cannot simply say, we want these actions to be taken and be like, okay, good luck. We need to have some oversight into that, some type of checks and balances. Just because new regulations new policies were put into place and manuals were sent out, well, how do we know that they're being imposed? And I want to go on the record and say that, even doing that still puts a burden on the board to micromanage when it should not have to be done. When you open a school, you are given a handbook on how to do so, and many schools do it.
What do you mean?
So, sorry, I lost my train of thought. All good. Oh, many schools do it, yes. So it can be done, and these are not shoot for the stars things that are unattainable. But if it is a difficulty to keep the time correctly or to understand how to be in compliance with the board, then I think a break needs to happen where we can understand what is expected, how to do it, ensure that it is being done, and then be like, yeah, okay, great, we're confident in this. Because at the end of the day, this school has the board's name on it, and we are responsible for those students coming out of there. And to say that no harm is being done is so irresponsible, because one boot camp led to someone learning a skill set that went out and created a home business, and they were actually doing a business. So it does have implications, and this board knows and understands how many times we see petitions, how many times we see citations going out to home-based salons, home-based businesses, people that think it's a hobby. It is just perpetuating the idea that this is for fun, and this is not. This is a serious industry that should be taken seriously, not lightly. It can cause harm. There is dangers associated with it, which is why we implement the things that we do on a school level. I appreciate everyone's time in stating their cases, both Council Brennan and our DAG, Joseph. I just feel like anytime we are put with this much detail and information on what is going wrong, it's a big deal. And I do love that Respondent Dixon took accountability on some areas. That's what I wanted to hear. Like, we know as a board, we're bleeding hearts up here. We do this all the time, multiple times a year. You come up here and you literally, lay it out. We obviously will bend and help as much as we can, but we cannot set precedent on this. This has to be fixed in a way, because this is a certain way, because this is the beginning of these audits, and it is not going to stop. And so we do not want something that, our bleeding heart allowed for in one moment to set precedent, and now we kind of have a standard that is below what we really expect for our board to uphold, if that makes sense. I think that's all I have for right now. But again, we've heard from the people that we hold to the fire on all of these cases, whether it's a school case, a licensee on a salon level, or a individual. And, you know, they present this, they know what they're doing. They did not take this lightly. And that is not to say that, you know, the opposing counsel did. It's just simply to say this was a lot. This was overwhelmingly a lot. And we have had a school in here before, and this was even more than that, in my personal opinion, which means nothing to anybody else besides myself probably. But it was a lot. And yet this weekend, I went and rewatched both days on the video, and I went through both days of transcripts. And I was overwhelmed with the things that I forgot or, you know, didn't remember, or that, you know, kind of came up time and time and time again. And it was very similar. And I just want for the record again, it was not the sanitation and this and that we are here today. It is what was listed in the complaints, which is what was listed by Attorney Brennan, the Category 2. And the Category 2 far supersedes Category 1 on anything, because it is how we justify if somebody can or cannot test, how we justify if they were taught well, how we can say we trust the school to do what it's doing, and we know that they taught this student to all of our requirements, and they have fulfilled their duty to the student to graduate and keep our public safe. And bookkeeping was a really big issue for me in this. I think I'm done talking for a minute.
Okay, this is Board Member Douglas. I agree with Wold and O'Brien 100%. And my concern as far as the business of Denise Dixon, I'm just trying to understand, how do you open up another business, but you're not taking care of the main business? I'm not for sure if this is her main source of income, but how do you open up another business, but you're not taking care of another business, and that's your main source of income? To me, I would focus on that instead of a new business coming in. And then also, I agree with Stephen McDonald as far as he's not here to close schools or salons. He's here to keep them open. And I'm glad that we have Janie Huggins, our Chief Compliance Officer, and Lauren Gossen, Regulatory Compliance Specialist. They did a good job. I mean, I'm pretty sure they're not here to close the school, but they're here to, you know, regulate like safety for, you know, the public. So I get all that. And my main concern is everybody did a good job. And kudos to your lawyer. I get what you're trying to do. And I just wish your client would have did better. That's my take on it. Thank you.
Thanks, Board Member Douglas. We definitely have really good teams on both sides, I agree, brought today, for this entire case. Board Member Harris, Moreno, Jeffers, I know you guys are online, but I mean, feel free to just interject whatever you're feeling and saying. If you guys have any comments or questions, things like that, what's on your minds?
Board Member Moreno. I also had a lot of time to listen to everything and reread everything. And the biggest problem to me, well, a couple of biggest problems to me, which I really didn't appreciate, is the threats by the attorney. If you don't go the way we wanted to go, you know, that was just like a constant in her throughout her whole statement. So to me, that was just a threat to the board. That's how I felt. I felt threatened by her if she wasn't going to like what our comment is, or what our deliberation would be. If it's just the issue of the time cards, that's the biggest issue here. We can't license people who are not being properly trained. And yeah, there could be some problems with, oh, the clock didn't work, or yeah, issues do come up, but it was a constant thing. So we have, as a board, we have to protect these kids. These are our future, because that's what they are. They're our future. So, I mean, I kind of feel like we've been here before. This is not the first school we've ever had to deal with issues. We've dealt with other schools. So this is not the beginning, and this is not going to be her school's not going to be the example. So that's all I got to say. And, our board staff did a great job in putting everything together, and, by showing the history to bring us to the present, that's where we're at. We're here at the present of, hey, what do we do here to make this right, to protect the public and to protect these our future. That's all I got to say.
Thank you.
Thank you. Hello, everybody. This is Board Member Harris. Can you hear me all right?
Hi, Roxy. You're great.
Oh, great. Okay. Yes, I'm going to piggyback off of everything everybody, my fellow board members have already said, but as like you said, it was a lot, and it's just a lot for us to wrap our minds around, and we've been here before. Yeah, and it's not good to feel threatened or have our capabilities threatened by somebody else who is actually not there doing what it is we're doing. We're all professionals in our fields, and we kind of know what it takes. That's why we're there. Like one of my board members stated before, you have to take some type of accountability for your own actions. You can't point your finger at somebody else's actions, somebody else's school. We're not dealing with them. We're dealing with you. You can't say, oh, such and such did it, robbed the bank. I think I'm going to rob a bank too. But Susie got away with it, and I didn't get away with it. I have to take what's going to come to me. I can't blame and point the finger at everybody. Yes.
Will you slow down? Will you start? How far back does she need to go? Can you start with rob the bank?
Oh, okay. Sorry, I forgot the court reporter was there. Okay, yes. So yes, if somebody else does something, just because they got away with it, not necessarily if you did, we can't point the finger. We can't play the blame game. Like I said, it was so much to have so much going through my head right now. And as we stated before, I spoke to Ms. Dixon before. Now we do, like my other board members said, we know things come up, things happen, things are in place. But she did assure us that she's gonna take some accountability. Maybe she wasn't there before to oversee her staff. She's going to be in the business a little bit more. She's going to fix the things. And I appreciated that. And I believe her, actually. And yeah, like I just lost my train of thought because it's just a lot. Everything's going through your head about, the time cards, the time records. Like one lady stated, oh yeah, I got paid for the 4th of July. The school was not open on the 4th of July. I mean, what are we going to do with that? That's fraudulent. So it's just a lot of things that just came up that we need to deliberate about like we're doing now. Well, like she said, we're here to keep schools open. We're here to keep our licensees working in the economy that we're in today. We're not here to put anybody, we're a board of empathy, compassion, and second chances. We're here to root for you. We're not here to bring you down. Only you can bring yourself down. Only you brought yourself to this hearing. Your school, your students, and everything else. But I don't want to see the students hurt. I just want to bring that up because she is willing to bring them back to correct the problem. Now, if anything happens and they're just out there, other schools are going to charge them money. They are. And that's not fair either. So that's why I said we have to keep in consideration and give everybody a chance. And but we have to do what's right. We don't need to be here again. I don't want to be here again. And then she stated, the lawyer stated, oh, the other schools you have 400,000. Well, yeah, those people paid their fines. They took accountability.
Roxy,
Some of them
slow
we
down.
have.
Roxy,
Oh,
Roxy, slow down.
sorry.
That's
Some
okay.
of them we helped. Some of them we could not. Some of them just say, hey, pay the fines. We had a student say, I don't care nothing about y'all, but he had to pay those fines. He said, okay, I'll do better next time. We've come across a lot, and I've been on the board probably one of the longest when the COVID was happening in the midst in 2020. So I know everything that went on, and I was sitting right there when we tried to help with the hybrid and all of that. So we get it, we understand it, but we need for you to stay and be in compliance at all times. I'm a board member. We all are board members here. We have, even us, we have to be in compliance. If my salon is not in compliance, guess what? They're coming to shut me down as well. They're gonna say, what is going on here? Nobody's exempt. You just have to do the right thing. But once again, I appreciate, she said she's gonna do the right thing. She's gonna make some managerial changes. She's gonna be at a little bit often. So when we spoke to her last in one of our other meetings, I just want to say everybody has done a great job. Like my board members just have expressed what their thoughts were. I agree with all of it. But we have to do the right thing. And yeah, I think that's all I have to say too. But I just want I'll say this slow. This was a lot. And a lot of it was very unnecessary. Do the right thing in your schools, whoever's listening, in your salons, in your classroom, even with your small certifications. Do the right thing. Thank you and have a pleasant day.
Thank you, Roxy. You're not done yet, though. You have to stay with us.
Oh, okay. Yes, that's right. Okay, I'm here.
She was like, have a nice day. I was like, not yet.
Right.
Not yet.
Not yet.
Yeah.
Thank you.
Yeah.
Okay, well, back to you, Madam Chair.
Thank you. Board Member Jeffers, how are you feeling?
Yes.
You
Hi.
Okay.
Yes, this is Board Member Jeffers. I just want to really talk about, I felt like there was a lot of minimizing of record keeping, that it's not important. And I have to say, as a business owner for over a decade, as a board member, and record keeping, it is fundamental. It is the foundation of what they need to learn in school, and obviously what business owners need to have. So that being minimized, I just don't agree with at all, because thus the record keeping is creating a safety issue. With the board staff not being able to look at the records and see that these students have learned X, Y, or Z, they are producing students that are putting the public at risk. So this is all like a domino effect. And like everybody has said, all the board members have said, it's not one thing. It is a year, months, years of infractions that have just spilled over the bucket. And this is where it has led us on day 3 of this disciplinary hearing. And, it's unfortunate because the people who are feeling it the most are these students who have paid a ton of money to get a career that unfortunately a lot of them aren't able to complete yet and able to go out into the public and earn money. So I'll be honest with you, I'm kind of like in my head, I'm like, well, what's the answer to this? Because we don't want all this to fall on the board staff and micromanage a business that's open. Like, they should not have to micromanage a school. There's too many schools for them to do that. So I don't know. I mean, I'm agreeing with every single one of the statements the board members have made, but I definitely want to say, like, as a business owner, if I don't keep good records, I get in a lot of trouble. So this isn't just like an isolated incident. This is something that the students need to learn from the top down. You take good records. You keep track of your hours. Like, this is a huge life lesson. So that's just my 2 cents.
Thank you. Board Member O'Brien, you touched on what my next point was going to be, and that was just to reiterate that when we say timekeeping and bookkeeping, we're not just talking about those time cards where the students write in that they're responsible. I am specifically talking about what the school is responsible for. For example, entering in students into the wrong categories, or their names or social security is incorrectly, program discrepancies, and then not staying up on the students clocking in and out for lunch or breaks. That goes to stolen time. And then it trickling down, like you said, the domino effect, then that's where those documents, those student records that they're responsible for keeping every day for the performance sheets, that's where those come in as well. More record keeping would be like, can't verify exam results, can't verify coursework, can't verify testing. They weren't even testing the students properly by using the proper grading format. They were giving half points when you're not supposed to do that. They were found to be teaching the students spray tan and permanent makeup. That's not a part of our regulations, so that should not be going towards theory hours. They were in violation of clocking hours for field trips, which again can be a little bit tricky, and I do know that they have, suspended that, but again, it speaks to the issue at hand and how big this micromanaging could be if we were to issue this. And, that is just kind of what I have on one page out of all of these other pages that I took. And it wasn't just for one student, it was across the board. This is not just, student performance sheets that are not required by laws being wrong. It was the biometric system was not being used correctly either. And that is a big deal. That's stolen time. And when you steal time, you're not actually getting education. And when you're not getting education, you are not able to go out and get your licensure in the same manner as somebody who did it properly and was able to get everything that they needed in their education. So we can go tit for tat. They did, they were on there, they just forgot to type, clock out. Oh, but they were twiddling their thumbs or watching their videos. We don't know. But the point is trust was broken because things were not done correctly as they should be. We have a parameter set. And it was not being followed. And so I just wanted to reiterate that when we say bookkeeping, it is not just what was brought up, in closing arguments today, but rather the first day of testimony with Bertha and Jamie. That was the most impactful on my mind for everything. And I feel like because that was months ago at this point, it might have been forgotten, but luckily by revisiting the notes, transcripts, and videos, it was fresh in my mind again about how big this really was, about the students going over 10 hours in a day or 7 hours, I'm sorry, not 7 hours, 10 hours in a day, or, I lost where it was at, but yeah. That's all I got. You're up.
Hi, this is Board Member Detry. I first of all wanted to tell you I appreciate everyone's time and effort in all this. It's a lot. And I rewatched everything this weekend because I wanted to give you and everyone here the responsibility that I was informed and as understanding of each thing that was being brought here today. I'm sad through all this. This is an incredible industry, and I know you feel that way too. I can tell. I think that you have to think about too all the students that are still waiting to get licensed and how many lives they're going to touch in their future, and it also has to do with how it affects their confidence and enthusiasm going forward because of the wait time that's been happening. And so I think the fingers of all this reaching out, there's so many people that are being affected. I do feel that everything's pretty much been said here, but I do see that we have to have some kind of reset. And how that is decided in the end here, hopefully it's fair to everyone and that compliance is followed first and foremost. But again, I'm just sad, and I hope we can find a good result here today. Thank you.
Thank you. Board Member O'Brien, I agree with you. I think that is the tone. I think there's also, for my end, I just don't know where we go from here, and I feel a little disappointed, and I mean no offense in this. I'm a little disappointed in how the case was defended, I guess, because I would have loved to hear more about what the policies are now, what they're doing today, not just we hired people and we're changing this and we implemented a new manual. What are you doing about how you're implementing the students in the portal or their names in the databases or checking them in and out, ensuring that they are, taking their breaks? What has changed along those guidelines or those lines? What are some other changes that you're doing as far as ensuring that students are doing what they're supposed to be doing when they're in their classrooms, and et cetera, et cetera? I would have really liked a lot more insight into what the school is doing since January 26th. That would have been probably more impactful than hearing how other schools need to be held responsible, et cetera, because that really went in one ear and out the other for me. I'm not concerned about other schools. Other schools will have their day in court. Today we're dealing with this, and this is what it should have been the highlight. But yeah, I don't know if at this point we're looking for a recommendation, board members, or if we have ideas to throw out there. But I kind of have a pit in my stomach because I just don't know what is feasible to do in this circumstance other than a reset. But to reset, like William said, is so hard because you have so many people that this affects.
Yeah.
So.
Board Member Walt, I took some notes from the defendant. And once again, I felt like it was really tone deaf, respectfully. I've been in this industry professionally since 2018. I got my license, and I've always really been big in compliance. I've worked at the Bathhouse Spa, the Delano. I've worked for Christian Dior. I've worked for really high-end luxury brands. So there was always a really high standard. And living in Las Vegas, one of the reasons why I came here is because of the hospitality industry. And so, the leadership that I received was very high-end. And unfortunately, I feel like the leadership is just completely lacking here. I'm sorry to say that, but unfortunately, like, the music speaks for itself. Like, even AI online is saying unprofessionalism, poor client service, demanding environments. Oh, sorry, unprofessional. It says reviews for the Cosmetology Institute of Las Vegas are mixed with notable complaints. Reviews for the Cosmetology Institute of Las Vegas are mixed with notable complaints regarding unprofessionalism, poor client service, and demanding environments. Despite a high rating on the BBB, clients have reported issues with hair services, lack of instructor supervision, and scheduling failures. Like, this is a AI. Like, not even a person, and it says student experience. Reviews from students or staff mention a demanding work environment with that time a lack of structure, training, or oversight, though some found it a good place to gain fast-paced experience. Complaints mention that management can be difficult to deal with and does not always address issues effectively. People, there's more on here. That's not positive. I'm not saying everything about your business is negative or that this is negative, but today I think that the standardized equal fashion of how this school should be treated, the last school that had horrible timekeeping issues, we shut it down. If we were to be fair, we would just shut it down and no reset. They didn't get a reset. They got their license revoked, and it wasn't a 3-day hearing either. I feel that there was a lot of fluff in this disciplinary hearing to prolong, to, maybe keep the school open. These are just my personal views. And then on top of it, we prolonged the school staying open, and the new people who got admitted, they have no idea. The students got on record, was it the March 9th hearing, saying that they received no information from the school. And that's really upsetting for me as a student. This case has actually had me really emotional. There's been days where I'm like, wow, like, this really sucks. because I don't want to shut down a school. I don't want these students to have to go find a new student home. I don't like that these students have to redo their hours, but we cannot verify. And ever since I've been in trades and the industry, never once was the tone that timekeeping didn't matter. Like, if you're there, you need to sign in. If you leave, you need to sign out. And so we have all these students who are at home saying they're signing their sheets. Like, never have I ever heard of this stuff. Never have I ever heard of instructors not being present, instructors not having their paperwork. Like, it's just so much. And so, you know, as much as I say, like, you know, a reset should happen, like, yeah, like, what does that look like, you know? And for me, the only way I can comfortably, I feel, move forward is that we do some type of revocation. I'm sorry to say that, Ms. Denise, but, you know, I see you're a serial entrepreneur, and as an entrepreneur myself, there have been times where I've had to scale back because things weren't done right, and I feel that the opening of the new business and the things I've seen on social media, none of it gives a tone that my school's in jeopardy and I need to do everything to make this right. And as just a consumer and a professional of the public, I just think that's wrong. When I was attending the school, we're in a probationary period. My first day of class, they talked about it. You know, that's transparency. Not, you know, signing away paperwork, paying someone $5,000, or I paid my tuition out of pocket. So that's hard-earned money from these students, some of them non-English speaking as well. So I just feel like there is a lot of harm here. I feel like the lack of instructor insight is harm to the students as well. They don't know what they're really being trained. If they read, they could probably pass their theory part. I don't know how the practical is looking, but I am going to assume in the next coming meetings we're going to have more petitions from students for verification of the hours, and if we keep the school open, who's to say this isn't going to go on for the rest of the year, et cetera, and I just don't want to see that happen, and I also don't want to fail our community and be like, you guys had the opportunity to do this and you didn't do it. You know, all the work our amazing staff went through. These are honestly some of the nicest people I have ever met in any industry. Very well-ran board. Mr. McDonald is absolutely amazing. He will not cite people, and he just wants to get them into compliance. And since day one, he's always like, we just want you guys in compliance. We are not in the citation business. He says that over and over and over and over again. And we are not in the business of shutting schools down. We don't want to see that. We are big advocates for our community. We love entrepreneurs. Like, you know what, I'm going to take the next step, and I want to lead the industry, and I want you to, I would like for Ms. Denise, if she chooses to want to lead, but I feel like there's some leadership lacking here. Just the tone of the defense, I felt like was, like I said, tone deaf. I felt like there was a lot of threats, a lack of accountability, instead of like saying, sorry, you know what, this is so much evidence. We need to make things right. We need to do something about this. Instead, it was like, this is not a big deal. This is unreasonable. We should have no accountability. We should not be in trouble. You know, people come on here all the time like, you know what, I did it. I just can't afford this. Is there anything we can do? Like, and I respect that so much more any day than anybody saying, oh, this is not a big deal. I didn't do this. It's like over 300 pages in just one file. Like, it's insane. This is the longest hearing I've had since I've been on the board, and also the most disappointing documentation I've ever seen. And it hurts my heart that this has been going on. And the statement you kept making, I felt like I was being gaslit, respectfully. I felt like, I was like, did we not see the same documentation here? But it's like, you don't revoke somebody's license. I heard that over and over and over again. You don't revoke somebody's license for being in compliance. You don't revoke somebody's license for trying to take accountability. We don't do that here. But what we do is we hold people accountable for failing to be in compliance. We're going to hold you accountable if you're not meeting sanitation standards. We're going to hold you accountable. Standards. We're going to hold you accountable if you don't have an instructor on premise and you have students practicing on the public. We're going to hold you accountable if you go and have students from a high school come to your facility and there's no documentation with the board for liability reasons and safety reasons to come into a professional instructor ran environment, and just think you can do whatever you want. We're going to hold people accountable. If I were to promote, or if any of us were to promote unlicensed professionals, like a high schooler came to our son's 12, they get fined for that. They get fined for their families coming in and helping wash hair. So that I'm not sure how familiar the defense was with our cosmetology industry. I felt like there was a lot of misunderstanding there, which kind of did not help the defense. But all this stuff is why possibly be a justification. And the fact that they brought this to us and that big binder sitting there of evidence, I feel like it speaks for itself. And I don't want to revoke someone's license because, I know it's a great pillar in the community. People go there, but it would just be like Wells Fargo, right? Wells Fargo is a great bank. People say, like, oh, you can open up and get $25, and they have this, they have all these benefits. However, when the bank causes harm to the people utilizing the resource, is it really a resource, or is it just a liability taken away? And right now, I feel it's really unfair to these students that they've gone through this. They're not getting the proper training to be the best esthetician, nail technician, just professional in our industry. And I feel that, continuing to have a school that's setting this type of precedence, this type of leadership where timekeeping doesn't matter. That March 9th meeting said it all, with those students saying they went back, changed their hours, subtracted their hours. The one who talked about being at school on July 4th, her hours were like way under, and she was just told, no, it's fine, it's fine. I feel like that's just unacceptable, and our board does not have time to micromanage. I feel like they've done a lot of micromanaging already. The email thread says it all, how willing they are. Janie is so willing. Oh, I'm sorry. How willing they are, and I just feel like the board has bent over backwards, and that's the only reason why they would bring this up to us today. So with a heavy heart, I feel like I would like to regrettably revoke the license, and that's just me.
Board Member Moreno here. Hello?
Yep, go ahead.
Board Member Moreno here. My reception is going in and out a lot. So I just want to let you guys all know that I'm going to probably have to sign off, but I trust that my co-board members are going to all do the right thing. And I agree with Board Member Wolf on closing the school. I think that's going to be the best thing to protect these students to go forward in their career, to find a school that will be able to work with them and guide them.
Thank you.
That's all I have to say.
Thank you.
You guys have a great day.
Thank you.
Yes, again. Hello, everybody. Again, this is Board Member Harris. So with all that being said as well, I agree with everything. But at the same time, let's come up with a reasonable solution. Let's meet in the middle, because we still have at least 35 students who are hanging in the balance. They still have to get their credits. They still have to do their credits over. Let's maybe think about at least letting them get their credits. The staff will tell us how long that will be. I'm not sure which, they all have different hours they have to complete. We've given them a letter of credit for a lot of them. A lot of them have to go back and finish 20 hours, 40 hours. Let's let those students who have already given their hard-earned money. It seems like a lot of those students just got caught in between. They were actually doing the right thing at no fault of their own. So if we could just maybe meet in the middle, let them finish out, because Ms. Denise did say that she's going to let them come and retake their hours. And I think after this situation and all this meetings, I'm pretty sure she gets it now. I'm pretty sure, because she got into the school to help people in the first place. She does active stuff in the community. So for me personally, it seems like she cares. She wants to do something better for somebody else. Yeah, she dropped the ball, absolutely. And her staff members dropped the ball. And some of the students dropped the ball. But we do have at least 35 students looking to finish so they can graduate, so they can get their license. Those are 35 lives, 35, at least 35 livelihoods. So I'm not okay with just leaving those students out. Yes, we did all that. It was in the past, but I believe that she can do it, at least for these students that are just out there. I know if I was one of these students, that would like so suck. I gave all my money. Yeah, and they dropped the ball on me. But somebody, like our executive director said, we're giving you a letter of credit. I don't know if that's to all the schools, but you have to pay money. She said she's willing to let these people come back if they want to and take their hours and do everything to make it right, make a wrong, make a right. Yes, I have a heavy heart as well. Like, I'm so emotional right now. Like, I almost feel like I want to cry. Like, but because I'm thinking about these other people, and that's what we're here for. We're here to help people, not to say, just we get it, yeah. And other people do wrong. Everybody dropped the ball once in a while. But like I said, we have to take in consideration. We got at least 35 more students out there looking for her to finish this, to correct this wrong from this school. And they're looking for that. And I just think we just need to take that into consideration as well. Maybe as one option, when they down to the last student, whether it be 2 months, 3 months, or whatever it takes, and then maybe revisit and let's see what she has done then. And then we'll know what she'll be doing in the future. We'll know how seriously she took it. If she let one of those students fall, then we'll know, yes, we need to, halt this. Maybe you need to take a 2, 3, 4, 5-year break. I don't know. But we still have those students. Let's not forget about those students who was just caught up in something. And that's all I'm going to say. I'm not going to drag this out. Hope I wasn't talking too fast, court reporter. But just take that into consideration. That's just my thoughts. And back to you, Madam Chair. I appreciate your time. Thanks for everybody's participation. And back to you, Madam Chair. Thank you.
Thanks, Roxy. Does board staff have a recommendation?
Well, hold on. Before we, Madam Chair, if it's okay with me, Senior Dag Todd Weiss, before we get into talking about what discipline should be, we have to go through separate votes for findings of fact and conclusions of law. It's a little bit convoluted, but it's the way we have to do things. Okay. So we have in the complaint here 66.
Wait, sorry, Board Member Wold. So is that if we move on, does that mean our deliberation is over, or will we be able to deliberate after again?
No, I mean, so I just want to make sure I'm getting this in before we start. Some people start throwing out motions and votes and whatnot.
Okay.
Certainly, if any board members have any further opinions or things to say, I think they should.
I do.
Yeah. Okay.
Thank you, Attorney. I just want to know.
Roxanne. Board Member Harris.
Yes. Board Member Harris. I'm sorry for the record. This is Board Member Harris. I would just like to say one more thing. I would just like to know, if it's possible, does Ms. Denise have anything to say before you, like you said, before we go making any type of motions or anything? What are her feelings at this time? If she has any type of statement she wants to make, is that possible for her to do so? Back to you, Madam Chair and Attorney. Thank you.
Yeah. Okay, go ahead.
I'm really glad that Board Member Harris asked that, because I feel like this whole time I haven't been heard. I'm not the type of person who puts my stuff off on anyone else. I've tried to take accountability from day one, which is why I asked for the training. The minute I knew that they were finding these discrepancies, I asked what I can do to fix it. None of that has been heard. None of it. I have worked tirelessly, even through grieving, to make sure that my school can be in compliance. I am fighting, paying money that I don't even have, for these students. This has never been about me. This has never been about money. This has always been about the students. Before it was even suggested that they come back and I not charge them, I was already allowing them to come back with no additional fees. I fight hard for these students every day. And just because I choose to have another business does not take away from how important I know that this school is, not only to the students, but to the community. A lot of stuff has been misunderstood, a lot, and I feel like I have not been heard at all. Nobody sees the work that we are doing. Nobody has been on that campus to see that these students are actually learning. I'm being penalized for doing more than what was required. No, it's not perfect, and I take full accountability for that. But it does not discount, that I work hard every day. And I've lost everything to keep that school going for the last 11 years. If it was about money, I would have quit a long time ago. I'm fighting because I don't want not just 35 students. I have over 100 students that are depending on going through this program and getting their licenses. To make assumptions that our students are not learning, I think it's just completely unfair when none of you have even stepped foot on my campus to see what we're actually doing. Okay, we are doing extra things like spray tan, but we're not taking away from what's required. We've always prided ourselves on giving our students more than what's required because we know that when they get out in the industry, they're going to be looking to do these things that are currently trending, not just what the textbook says. I understand that. And the minute we were told that we couldn't do it, we eliminated it. I'm not here to fight against anybody. I've always tried to work with the board staff. The minute I had a conversation with the executive director, all I wanted to know was what I'm doing wrong. Because truth be told, we were never monitored for our documentation up until September of last year. That's the God honest truth. So if I thought I was doing it right and I wasn't, I asked, how do I correct it? Period. And the minute I was finally given that list after asking multiple times, I corrected that. You guys are looking at things that they came and did a big swoop of documentation, so of course it looks like a lot. If you're taking 40 files at one time, of course it looks like a lot. But you're not taking into the account that there are students that have come in after the fact that we are making sure that they are doing things right. We can't do anything about the past. You're probably going to get more if you have students who graduated 2 years ago and are just now going to take their test. You're probably going to have more. There's nothing I can do about that because I'm not altering documents. I'm giving you exactly what we have, and I have done exactly what the law requires. I have the main record of time, and I have the final record of time from the student, and that's all that I'm required to do. But I was doing more because I wanted to make sure I was already, from the day I opened this school, I was already having odds set against me. So do you think that I'm just going to purposely drop a ball when I know that I'm already being looked at and being watched? It's not new. This has always been a thing. And all I do is I work hard every single day. Please don't look at what you see on social media and assume that you know who I am, because you don't. You don't. Social media does not tell my story. Having more than one business does not define that I don't know how to run a business. It does not, and it's just not fair that I feel like I'm being judged every single time I come in here and I haven't had a proper chance to even fight or plead my case. I invite all of you, just like I did Stephen, come to the school and see for yourself. Come see for yourself that we are teaching students, that we actually do care about the students. I've let a lot of staff go because I don't care how much you know. I care how much you care, and so do the students. To me, it's just like, I know that the minute that I got the list of things that they were finding, we made these changes. We now allow these students to monitor their time without making any edits. They can see what they're actually clocking, so they can make sure that the documentation adds up. A lot of it was misunderstanding about signatures. It's like, okay, so we're going to just completely do away with that student, what they actually did, because the signature is off. Like, that doesn't justify that they did not do the work. Like, they did the work. I know that they're doing the work. These students are sacrificing every day, having kids, having jobs, having families, having family being deported. Like, we get all kinds of issues, and all we're trying to do is make sure that they reach the finish line. That's it. That's it. We now get notified if a student doesn't clock out for break. We've gone through our entire system to make sure that we can hold these students accountable as well as holding ourselves accountable. So if they don't take a lunch, we know. If they go over 10 hours, we know. But again, none of this was ever even an issue or brought to our attention until late last year. Why have I not been given a fair chance to actually fix it? Which I have. So if you continue to see that, by all means, I'll walk away myself. But I haven't been given a fair chance to turn it around. And I've been working tirelessly to turn it around. On top of everything else that I have going on, I don't discount anything. I don't make excuses for anything. I haven't even had a chance to properly grieve because I've just been moving, trying to get through this whole situation. My mental health has been affected. My finances have been affected. This is a lot. And I understand that these students are struggling. They came to school, they struggled through school to be able to go and get a job and change their life, and now they're still being held up. I don't sleep at night because I'm concerned about these things. I want this to be over with. But if you feel like this is just for me to just be completely shut down, I don't think that's fair, because I haven't been given a fair chance to fix it.
All right. Thank you. That's what I needed to hear. That's what I was waiting to hear for both days, honestly. I have a follow-up question. I like the statement that you had said about you can track now when the client, or when, excuse me, the students are in and out for breaks and lunch and things like that. What other changes have you made specifically when it comes to the other issues that you were getting help from the board staff for? That was one of the things that was an issue, but like, what about the inputting students and things like that, and then like them switching into different programs? Have you kind of found a solution to that as well?
Yes, and I also want to point out that I've also, like for instance, I myself put students in the portal because I do their orientation. And please believe that during orientation, they are fully aware of what's going on. And I'm stressing to them how important documentation is. And they're fully aware that I'm going through this situation right now. So the fact that statements are being made about, that's not who I am, first and foremost. But I make sure that when they finish through orientation, we get them into the portal. There's a couple of situations where I've gotten responses from the board saying that the student was put into the wrong school. I responded to them and let them know, when you go in and you type in the first 4 letters of my school name, my school is the only school that pops up. So if that's the only option I have, how is it that they're being put under another school? That's a portal issue. Or the fact that we have students who are showing active in the portal, and when we get ready to complete them, they're saying that they're not in the system. I'm sending screenshots showing they have a student number and they're showing active. How is it that they're not showing active on your end? So I do feel like that there needs to be accountability across the board, because I'm not purposely trying to do anything wrong at all. But I am making sure that they get put in on time. I am making sure that we have made changes to the transcript because there was confusion there. I am making sure that the performance sheets are adding up. We are telling these students, you can't keep rounding up because it's going to throw your numbers off. If anything, if you can't do the exact math, it's better if you round down, because it's better if you have more hours than not enough hours when they actually go through it. But I'm going through all of these changes, and I'm making sure that they do what they're supposed to do, as well as my staff doing what we're supposed to do when it comes to putting them into the portal on time. And when it comes to making sure that we have those final records of time and that we have everything so that when they ask for it, everything is aligned. But I can't do anything about the past.
Agreed. You mentioned, I think the last, board meeting, you had a training with your staff regarding how the testing is supposed to be done. Is that something you're going to continue to do and follow going
We have
forward?
another training coming up in the middle of June as well.
Okay. Thank you.
Board Member Wolves, thank you so much, Ms. Denise. Sometimes when you're represented, it's hard because the lawyer is speaking for you versus being able to put your input in more. One thing that kind of soured the defense for me was I felt like there was a lot of justification. And so it was like every instance that there was like, oh, well, this is why, this is that. So like, for example, like for the boot camp, like, well, we didn't know. This is all in the law book. When you have to reach out to the board for certain instances, just like the field trip, it's in the book. And so my concern is how often are you opening your law book?
I can't say that I know it like the back of my hand, no.
Okay. When's the last time you read the law book?
Prior to this, because I've been reading it a lot lately.
Yeah.
So, prior to this, periodically, not a lot.
Yeah. And when you guys are doing your Nevada law theory, what is being taught?
We go through everything, and like we go through the book. We teach Nevada law pretty much every Saturday. That's part of and Fridays and Saturdays is when we do Nevada law.
So what type of compliance are you teaching your students?
Anything that's required for them as a student and as a licensee.
Okay, because this is the big thing for me. For compliance, a lot of your issues is due to not following the book. And so unless we start like reading the law book, you can make these other changes as far as like timekeeping. We appreciate that. The other things you just spoke on. However, like the justification of the boot camp and, having the students there, the provisional instructor not really being a provisional instructor at that location, those things are 101. And my issue, I appreciate your sentiment. This is not fun for me either, but if you're not going to follow the law, you know what I mean? That's the big issue here. And so, we can sit here and we can talk about what we're implementing, but if we're not truthfully like studying the compliance, we're going to have more compliance issues down the line. And so my concern is like, we had a conversation with her. She was empathetic. She said sorry. But if we're not fixing the root cause, the tree is still going to have bad branches. And so that is my concern. I don't want the students to be harmed. I don't want you to be harmed. I'm sure this is a lot. It's a lot for us too. And so I don't know. I would like to see more imposition there because that book is your friend. That book is going to keep you out of trouble. I don't know. Do you have like a compliance officer, or how are you guys going about your compliance at your school?
No, I don't have a compliance officer, but we are all taking accountability and studying the law and making sure that we're staying in compliance.
And when you like make certain decisions, are you being advised by anybody, or are you just making these decisions alone?
Primarily, I make the decisions on my own, but I do have people that I can talk to who are familiar with the industry and have experience. I've had consultants in the past when I went through my national accreditation, and so
because to be honest, I do want to keep the school open. I just do have a fear of long-term change not staying, because it starts.
So what exactly is your fear, though?
My fear is that you're not going to make real changes.
But I already have.
But this is my thing. This case is from 2020, some of the instances. So today's 2026, and they have this rap sheet as big as that book, and that's not everything. But that's everything that was submitted into evidence. And so my issue is, okay, you know, it's like when a child does something bad, spank them on the butt, okay, they stop doing it, then they go back to doing it later because it's habitual, it's a pattern, it's a rhythm. Right now, you've been in hot water, so of course, right now is going to be the time we see the most changes, the most implementation, the most, hey, do this, do that, and then, you know, bad habits die hard, I just don't want our resources having to go back to this. That is my fear. I don't want to see more students not being able to test. That is my fear. I don't want to see discrepancies in time cards again. Those are my fears. And so
this is the first of that. This hasn't been habitual. It's just been a lot presented at one time.
No, it is actually has been habitual. You just haven't gotten in trouble for it.
It's not.
Okay, well, I'm not going to argue with you, but that book, without talking, that book speaks for itself.
It does. I went through it extensively.
Those time cards speak for themselves. And if you went through it extensively, then you should be able to see that there's a habitual problem here.
There was a bunch of files that were taken at one time. That's not habitual.
Okay. Ms. Denise, that is my problem here today with you.
No, I take full accountability. I want to be fair,
I'm not
though.
gonna argue with you. Thank you.
Guys,
I'm not gonna argue.
okay. I allowed some questioning essentially because we're going to get to discipline at some point for mitigation or aggravation, but this is not an argument. This is not a back and forth. If there are any questions board members have that they will need to have answered as going into discipline, I will allow that, but we need to keep it focused and on the issue of discipline, essentially.
Okay.
So, process-wise, the first thing we need to have a vote in motion on is the findings of fact. The complaint is our guide on that. There are 66 separate factual allegations made in the complaint. So at some point we will need to have a vote on which of those 66 findings of fact the board members find have been met by a preponderance of the evidence based on the testimony and submitted evidence only. I'm not a big fan of doing block votes, so I mean, I don't want to. I mean, I don't think we need to do each of the 66 facts a separate vote. But maybe what I would ask the board members to do is to review their complaint through the 66 facts, and if there are any that they do not believe haven't, or if there are any that they believe have not been met by the required preponderance of the evidence, then bring that forward, and maybe we can reach agreement on the members on which ones have been met based on that. That may be the fastest way to do it. There's not too many quick ways to go about this, unfortunately. But I'm not a big fan of just saying 1 through 66 have been met, because we don't. I think another review is needed before we can determine that. So maybe the members can take 5 minutes to go through the 66 factual allegations that are in the complaint, and take a note of any that they do not believe have not, or they believe have not been met by the preponderance of the evidence, and then we'll have that discussion, and then we can take a vote.
Thank you. At this time, board members, please review pages 2 through... One second, I see your hand, 1 second. 2 through 14, please, on the complaint. And as you go through that, please list any that you are not thinking that we had, that you're not comfortable saying that you found to be factual. Yes, you had a question?
Yeah, sorry.
It's okay.
Don't want to interrupt, but I feel like the record should reflect that one of the board members left a while ago. Is that correct? And which one?
That was board member Moreno. She said she was getting off. Do you want us?
I just think it should be stated on the transcript that board member Moreno
Okay.
is no longer and hasn't been here for a bit and is not participating in the deliberations.
Sure. Board member Moreno is not online. She got off about 15 minutes ago due to connection issues. Thank you.
No,
All right. At this
no
time-
objection.
Oh, I'm sorry.
Also, since we're doing this, can I have it on the record? I don't know if you guys did this at the beginning. I might have missed it. Did everyone review the transcript who was not present for all of that? And was there video too that you guys were sent?
There is video.
And you guys watched it as well?
Yes.
Okay.
Yeah.
Can each individual say that on the record?
Board Member O'Brien, I spent all weekend reviewing the videos and transcripts for this case.
Board Member Guidry, I spent also reviewing videos and transcripts in this case.
Board Member Wold reviewed the YouTube videos, even some that were related to this on our quarterly hearings, and the transcripts on this case.
This is Board Member Douglas. I also reviewed the transcripts. Sorry.
Board Member Harris, I reviewed the transcripts.
Board Member Jeffers, I reviewed the transcripts as well.
Thank you. At this time, please go forward with reviewing those documents. We will get started once everyone's finished.
I'm sorry, are we?
Yes. Oh, yeah.
Yeah, that's.
Just was stating for the record, lunch is here. We could break for lunch.
Let's,
If
no. Sorry.
Board Member. I'm sorry, I just wanted to make sure, is this the 4A cosmetology?
It is.
Okay.
Yes,
just wanted
it's
to make
pages
sure.
2 through, I think I said 16 or something like that. And 14, okay.
Okay.
And then, yes, we'll go off record while we review this so court reporter can take a break. Thank you. Board Member O'Brien, has everyone had time to review the counts?
Board Member Wold, yes.
Board Member Detry, yes.
Board Member O'Brien, yes.
Board Member Jeffers, yes.
Board Member Douglas and Harris, have you had time to review the counts? Do you need more time? Board Member Harris,
Yes.
have you had time to
Good
review the
morning.
counts?
Yes.
Awesome. Thank you. Board Member Douglas,
Yes, ma'am.
have you had time to review the counts, or do you need more time?
No, I'm fine. Thank you.
Oh, wonderful. Okay, then at this time we'll go forward.
So, Senior Dag Todd Weiss, so having those been reviewed, I guess now we would have a discussion between the board, amongst the board members, if there are any of those 66 that they believe have not been proven by preponderance of the evidence with the testimony and admitted evidence in this matter.
Board Member O'Brien, board members, do we have any of the counts that we feel were not backed up by evidence?
Board Member Wold, no.
Thank you.
Board Member Detry, no.
Board Member O'Brien, no.
Board Member Douglas, no.
Board Member Harris, no.
Board Member Jeffers, no.
Okay.
Okay, so that being the case, we will be looking for a member to make a motion to make findings of fact consistent with paragraphs 1 through 66 of the complaint. Yes, that's fine.
So moved. Can I have a second?
Yes, second.
I, Board Member Wold, second that motion.
All in favor?
Aye.
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 Any opposed? Motion carries.
So then we need a separate motion and vote on the conclusions of law, which most usually that's the easiest way, is to just go based on the counts that are in the complaint. In this case, we have 13 separate counts. Again, you need to make a finding that each count has been proven by a preponderance of the evidence based on the testimony and admitted evidence in this matter. If the board members are in agreement that all 13 counts have been proven by preponderance of the evidence, then you can do it in one single motion.
Okay. Board members, have we had an opportunity to review the counts? And if we have, were there any that we need to discuss that did not have a preponderance of evidence behind it?
Board Member Wold, I have read all the counts and I don't dispute any of them.
Board Member Douglas, same here.
Board Member O'Brien, same.
Board Member Detry, I'm in agreement.
Board Member Jeffers, I agree.
So Senior Dag Todd Weiss again, if that is the case, then
Sorry,
we are
Board Member
looking-
Harris, I'm good.
Sorry, Member Harris. Then we are looking for a motion to make conclusions of law consistent with counts 1 through 13 of the complaint. Yep.
So moved. Can I have a second?
I, Board Member Wold, second that motion.
All in favor?
Aye.
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 Any opposed? Motion carries.
Okay. That being the case, then we are on to discipline. So, I mean, there's a lot of options the board has on as far as where they want to go with discipline in this matter. There can be administrative fines. There can be continuing education for licensee. There can be revocation. There can be suspension of license. And if the board is interested, I can explain the difference between those two things because it's often confusing. Am I missing anything? Fines, revocation, suspension, and possible continuing education for the individual licensee are all options available to the board here.
Okay, thank you. And at this time, we can ask for the recommendations from board staff, correct?
Yeah, you know, we've allowed the respondent to be heard, so we can also hear from. Yeah.
All right, at this time, can we please hear from Executive Director McDonald for board staff recommendation for us to consider?
Yes, thank you, Madam Chair, board members, the respondent, and counsel for the respondent, Ms. Brennan. In hearing the deliberations today, and I guess the additional questions that the board chair allowed of the of Ms. Dixon, we're going to recommend that revocation not occur. We're going to recommend that the CILV be put on probation. And no need for me to go through all the record. We've proven it, and the board has already voted that we've proven our case. That's, I guess, one of the benefits, or not the benefits, of being a lawyer myself. So, and doing civil practice as well as administrative law. So, for the first, I guess, discipline, we would recommend a year probation, not revocation, because revocation would be a minimum of 1 year. That means you would be shut down. You can't operate without a license, right? So board staff is not recommending that we shut you down. We're recommending that you be on probation for a year. And the reason why that long probation is because you have students in cosmetology programs. You have all the programs there. So that's the reason why. We want them to finish up in those programs. So that's the first part of our recommendation. Administrative fines, we've proven them. So all 13. But what I'm going to recommend on the administrative fines is that you not discipline on count 1, the proper supervision, because she was cited for that. I'm going to recommend that you not fine her under count 11, which is the enrollment of registering students within the portal within 30 days. We recommend that you not discipline her, CILV for that. And count 12, we recommend that you not fine her for that because she was cited for that, citations. So taking away 3 of the counts, even though we've proven them all, we would recommend that those 3 counts not be disciplined on, up to $2,000. So those are 0. We would recommend that. The others, count 2 through 10, we recommend a fine of $2,000. So that's that part. Now here's and of course the attorney's fees and costs are taken off the table at this point. But part of the probation, Madam Chair and board members,
Board Member O'Brien, can we go back to the counts, please?
Sure.
You said no discipline or fine count for 1, count 11, or count 12. However, you said count 2 through 10, we're going to do the $2,000.
Oh.
Did we leave out 13?
yes, my apologies.
Okay.
Count 13 is to be fine. That we would request discipline on.
For 2,000.
Right.
Okay.
So 1, 11, 12, correct.
Okay.
13, yes.
Okay.
As part of their probation, part of CILV's probation, year probation, we would request that the school lessen the amount of programs that they have. Because based upon the facts in this case and the violations, staff believes, and I believe that the board has the same reservations, that having all those programs at that location is unmanageable. So we would request that, based upon NAC 644A.600, that either option 1, she has the cosmetologist program, or a combination of the 2 smaller programs, such as aesthetics and nails, option 2. We do not recommend that she have the AE program. That's the Advanced Esthetician program. And specifically, this means that there will be no other programs than the programs resulting from this board decision. If more programs are allowed, it would need to be contingent upon a variance, which was going to happen anyway, because she doesn't have the square footage. She would have to come before you again anyway. We already knew that. Example, cosmetologist programs, for each 25 such students in attendance, at least 5,000 square feet of floor space. I think from our knowledge, she does not have that. 5 and 6, okay. We could get that clarified. If it's going to be estheticians, each 20 such students in attendance, at least 3,500 square feet of floor space. And nail technologists. Okay. Nail technologists for each 20 such students in attendance. I'm actually stating what the reg says. NAC 644A.600. I'm sorry, this is going to be long, a lot of conditions here under probation. If the school enrolls a student under another program, the hours won't be accepted and CILV shall be considered in violation of the conditions of their probation. If offering cosmetology, depending upon what CILV chooses to do, remember the first option is just have the cosmetology program, cosmetologist, or do 2 of the lesser, or I shouldn't say lesser, they're not lesser, but it's 2 of the smaller programs, okay, together. Then if that's going to happen, if the board wants to allow her to have the cosmetology program, the nail room and aesthetic room shall be turned into theory classrooms. If offering aesthetics and nails, the school must purchase more pedicure stations and comply with current and future equipment requirements. The aesthetic classroom must be separate from the practical area. The shampoo bowls and hair equipment would need to be removed. Depending upon the outcome of the programs that CILV would select and that this board will allow them to have, there shall be no new enrollments until the current ones are taught out. No one currently enrolled in the school portal will be accepted under this teach out. A list of all students should be provided to the board by end of day today. All withdrawals must be submitted as soon as possible. Any delays in the student information should be considered punishable, as we are imposing these specific requirements to avoid any possibility of the school circumventing the board's order. The school should be required to adhere to a specific class schedule. That was also a finding that we could not seem to get a handle on. Based on, again, the outcome of the programs that the school, based upon the options that I've given you, that she selects and that the board is willing to vote on, to allow her to have, we recommend a day program to run between approximately 8 and 5, Tuesday through Saturday, and an evening program to run approximately 5:30 to 9, Monday through Friday.
I'm sorry, what was that, Board Member Wold, what is that, an evening recommendation?
It was 5:30 p.m. to 9 p.m.,
Thank
Monday
you.
through Friday.
Thank you.
And part of this probationary period, the school is not able to change the schedule without prior authorization by the board staff. Students must adhere to the school's schedule. Makeup hours must be approved by the board staff prior to the student's change. Board staff will review and approve schedule changes within 1 business day. I realize we're getting into micromanaging, which is not what we want to do, but because of the circumstances, board staff, executive director, and staff has to get involved. The school must have at least 2 instructors, this is under the law already, for each program schedule and an additional teacher as a substitute. If there are not 2 instructors present, the school cannot be open for that day. The board should be notified of any changes. Instructor attendance should be logged and provided to the board daily, along with the student attendance requirements outlined below, and I will go through those. The school must have a designated registrar who is not an instructor. It is also preferred that the registrar not be the school owner. Anyone entering information in the school's portal must use their own user login. Logins should not be shared. Student records for hours must be accurate and reflect only hours that were actually earned. The school must maintain student records properly. Any documents for student records, attendance, services, etc. are kept on campus in the students' files. No documents from the schools are to be taken home by the students. Student punches with errors must be corrected in accordance with the applicable regulations. If the timekeeping system is broken, which you've heard through much testimony over several days of hearings, the board must be notified immediately, and the issue must be corrected immediately. Only the actual supervising instructor may sign off on hours. Students cannot change schedules without prior approval from the board, or overlap from day to evening class unless explicitly approved by the board staff. I only have a page left, Madam Chair. I'll have this in writing for everyone.
Oh, lovely.
A daily attendance log must be sent within 30 minutes of the program's end times from the school to the board staff. And here's an example for the record. If the program runs Monday through Friday, 8 to 5, the daily hours from attendance and any other applicable timesheets, either provided by the board, because we actually have been providing timesheets for some of the students. We actually have a form from them. When they're actually going in, they have a letter of credit. We've given a form for them to go back to the school and say, this has to be completed by the school and you, student. We actually we made a form because of the situation. Must be sent by 5:30 without exception. School instructors therein must comply with all applicable laws, regulations, and policies of the board. The school and its staff are responsible for maintaining a working knowledge of the laws and regulations that govern cosmetology schools, as well as for asking for assistance or clarification to ensure compliance with these provisions. We are always available. But we have limited resources too. I've always said this before. I don't have 2,000 inspectors. I don't have 2,000 inside staff. But we do our best to have you comply. If the school fails to comply with the regulations, it shall be considered in violation of the conditions of the probation. Okay. Staff recommends that the school be ordered to pay the full costs and attorney's fees. That's off the table. Related to the investigation, off the table until for to be determined. This is the last part. The following conditions are regarding any possible future violations of law or the conditions of the probationary order that we're asking you to give to CILV. If the school violates any of the conditions outlined, it must voluntarily surrender its license upon notice by the board staff. If the school voluntarily surrenders its license, the school must comply with the record-keeping requirements set forth in NAC 644A.625. If upon notice by the board staff that the school is in violation of these conditions, the school remains open, the school will be brought before the board for revocation. So those are the long conditions of this situation. This is somewhat consistent with what happened with a prior school. So we're not, Kleenex please. So that, excuse me, I want to say court's indulgence, but board's indulgence please, thank you. So we are somewhat consistent with the prior school, which the prior school I recommended revocation, and the board did not agree with me. So this is not the first school that we've dealt with. So those are the conditions, Madam Chair and board members. I know it was long, but I had to put that on the record so that it's clear. It will be, of course, court reported on all of that, and that's our recommendation.
Thank you. Yeah.
If the board were to follow your recommendation, I guess what I'm confused about is, I don't know, are there students in other categories that would be their hours here? For example, if you're saying that you didn't practice and that you teach, if they as a position, then would those students have to go somewhere else? Or she could finish those out?
This is Janie Higgins for the record. There is a small area in that recommendation that speaks to what we are referring to as a teach out. So any additional students that don't fall within the remaining program, there would be room to give them a teach out and complete their program hours.
Okay, okay. But the school would not be able to accept any new students whatsoever?
For the programs that would be removed, no.
But they could accept new students so they could continue to pay their overhead and bills, but they just have to pick option 1 or 2? Is that what you're saying?
Madam Chair, if I may address the council.
Yeah.
Yes, the two options that were given,
Okay.
they said there's too many programs there.
Okay.
Those have to be narrowed. So the one option, because it's a full program, is a cosmetology program, which you can do all 3, right? SD, nail,
Okay.
and hair, right? Well, that's a full program in itself. But she has not just that. She has all the separate programs, and that's where the record-keeping
Okay,
problems happen.
so I just wanted to be clear. I'm understanding what you're saying, which is she would have to pick one of the 2 options, let you know which one, and then follow those rules for that. But she could accept new students to help pay her overhead in whatever category it is and follow the rest of this. And then you would allow a teach out, which would mean if there are students currently there that need to finish that earn a different category, we would talk about that and she would be able to teach them.
Yes, that'll be
Okay.
part of the teach out.
Okay.
Absolutely.
Just wanted to make sure I
Make sure, yes.
Thank you, Stephen.
You're welcome, very welcome. Thank you, Madam Chair.
Yeah.
I'm sorry about the long conditions.
Okay.
And council has one.
Yes, Joseph Ostrunio for the record. The last thing I would like to add to Mr. McDonald's recommendations is board staff would like leave to file a motion for attorney's fees pursuant to NRS 622A 360 5B and NRS 622A 390D. Thank you, Madam Chair.
Thank you. Board members, we have a recommendation on the table. Do we have any questions or comments? Are we comfortable with this recommendation? Do we have anything that we want to add into it? How are we feeling?
Board Member Detry, my concern was with the teach out.
Mm-hmm.
Students that are already there when she chooses an option, that they still get to complete the program that they're involved in now. So that was my only question.
Board Member Wold, I think for me, this is a lot of conditions, and I respectfully don't have that much faith that they would all be met. So, however, I would like for the students to have opportunity to get their credits and finish out. But I'm not crazy about the recommendation. However, because it's not just it's the students can't control their leadership. So, no, that's how I feel about that.
Anyone else have any comments or concerns?
Yeah, actually, sorry, Board Member Wold, one more thing. For board staff, as far as, I guess following up on like adding more pedicure chairs, a designated registrar, how are we going to go about that? Is there going to be like a time frame imposed of like this person should be done by this time? What is this monitoring looking like?
This is Janie Huggins for the record. There were recent changes to the school curriculum and equipment list that just went into effect 2 weeks ago, which would require all schools to purchase additional equipment. So we would give all the schools the same opportunity to purchase that equipment. That plan has not gone out to the schools at this time.
Okay, and then also another question is, the registrar as well. How are we going to monitor that? I know it was a recommendation. Is this a imposition or?
Huggins for the record. We believe that because the bulk of the issues relating to the records would technically fall on the position that we have outlined in regulations as the registrar, which is why we don't want it to be a staff instructor. If that person happens to be a licensed instructor, that's not what the goal is there. We would monitor that the same way that we continue to. When we receive a student enrollment, they verify if it was over 30 days. It's not a new regulation, but another thing that we've been given citing power as of the last 2 weeks over that they will be checking compliance for is if the student is not withdrawn or completed in a timely manner. We will be checking that through the registrar, and then whatever assigned staff from the board we have for this, they will be receiving daily records from the school.
Okay, and then apart from Board Member Wold, apart from the monitoring through electronic, how often are we planning to go to the school to ensure?
This is Janie Higgins for the record. The schools are inspected every quarter. So at a minimum, it will continue to be inspected every quarter. We also do records, desk audits of student records, which those will continue. In the short term, depending on staff availability of the board, we may increase those audits to reduce the load off the licensing staff who's reviewing on testing application to ensure compliance with those requirements that are being imposed on the school and its registrar.
Okay, and then one more question. If they fail to do any of these provisions and they don't surrender their license voluntarily, they're like, oh, we had new enrollments that passed the period, or oh, this person withdrew 10 days ago, we're just getting to it 15 days later. that would provoke them to have to submit their license. And if they don't, then we would have another hearing like this. Okay. That's all my questions for now.
Okay. Roxy, did you have a question?
Yes.
Or
Excuse me. Yes. So I agree. I like the recommendations. I'm gonna say I hope they get. I have faith. She's gonna meet them. It sounds like a good plan. It sounds like correction will be done. And yeah, that's where I'm at with you. Thanks. Back to you, Madam Chair.
Thank you.
This is Board Member Douglas. I like the recommendation. Also, and I would like to tell Ms. Dixon good luck in the future.
Thank you.
This is Board Member Jeffers. I as well like the recommendation. If after this year it goes swimmingly, she does a great job, can she come before us again and bring on those sub-programs like the nail design and the aesthetics program?
Board Member O'Brien, it would need to be under a variance due to the size of the school.
Or is that just the AE? Or is she over capacity right now as is?
As is.
Oh, okay.
Yeah.
Yep.
So
I said, Board Member Will, that was one of the issues brought up in the complaint was the square footage, but board staff was trying to work with her as they have with other schools.
Yeah.
So they were already going to need a variance no matter what.
I see. Okay.
Yeah. Yeah.
Thank you for bringing that up.
Yeah.
If I could ask Stephen a question. I guess my concern is about how, my concern is if Denise is making a good faith effort and really attempting to do all of these things, and I mean, we're expecting 100% perfection, and if there's a hair in the student's brush in the drawer when they come out, their license it's gone. Like I mean, I want to make sure that we're all going about this with the same understanding that she's going to be doing everything to make this work. But if there's something that happens that it's not immediately, we're all done at that point. Like I mean, obviously, if she's got a pattern of not doing things, that's one thing, but like I don't think you can expect any school to be perfect 100%. And I mean, that's part of this probationary period, is to help make sure that she gets this right. And I just want to make sure, you know, because if she gets it wrong and she's really trying and like working with them to get it right, I want her to be able to still be able to get it, not be thrown off probation. So how are we going to handle that?
Madam Chair, I can reply. Yes, I think during the testimony it's come out pretty clearly that we're reasonable people here. Okay. I've tasked my staff to be professional, respectful, reasonable. No, we're not going to, it's not an automatic, surrender of the license because you find a hair in a brush. They've seen these hearings a lot. These board members have been on this board for over 4 years. So when they see the breadth of what's in the cosmetology and the breadth of what we do in trying to assist these licensees individually, the salons, spas, as well as the schools. We don't, as an example, they've made this, the cheese graters, right, that go on your feet. There's like, we could cite for each cheese grater that we find at your location, at a salon, at a spa. We've only cited for one. So we're reasonable.
Yeah, I just want to make sure we've discussed that.
Yeah.
And
but I'm glad you asked that question.
I just want to, because if one thing happens and, you know,
Sure.
I don't want this all blow up at that
Absolutely.
point. I want to try to keep correcting it.
Sure, Madam Chair and board members, you know us, right? And I hope that that the respondent and counsel noticed that I've been here. I'm in my 4th year here, so I'm not trying to put people out of business. We're in the compliance business, not the citation business. We're not here to try to make money off you. That's not our deal here, because we know mistakes happen. The key is just getting in compliance and ensure that she's in compliance with these conditions. As I said, this is 2.0. It's our 2nd school in my tenure here. That just shows how little that we do this. It takes a lot of work to do this, and I have limited resources, so we don't take these things lightly. When we do have to bring someone before the board for disciplinary action, we have over 20-something schools statewide, and I've only had to deal with this twice in the 4 years I've been here. That's a low rate. If I was really out to get the schools, I'd be bringing them in all the time, okay? But the schools are actually working with us, getting compliance, and doing what they need to do. We just weren't getting the assistance, the partnership, unfortunately. And that's why I was put into a corner and had to do this. I hate having to do this. It takes a lot of work, and it takes their time. They are business people, just like respondent is here, Miss Dixon. So school is a business. I understand that. But we also have to enforce the law. Okay. And we do it equally, and we do it respectfully. We do it passionately. That's why, as part of Council's closing statement, that we recognize what she's done for the community, in that community. So this is one of the ways, Madam Chair and board members, that we feel that there is a compromise here, instead of, and I could have recommended, as you've heard me before, recommend revocation. I'm not recommending that here. I'm recommending that she stays open, that she allows the students to complete their programs. We're giving them letter of credit. You've heard in other testimony and other hearings with the students of what they're having to deal with now, and we are bending over backwards like pretzels to give them as much credit as we can. That is documented. They're under oath. These students are under oath, and we're trying to do our best for them, as well as for Ms. Dixon, to stay in business. The key is you got to work with us to get you there, and for the students and for the public. Ultimately, it's the public, because if a person's not able to, if we cannot verify that they had the training, the hours, and they're out there and they get passed and they get licensed, and then somebody gets hurt, that's where the complaints happen. And that's where, as the regulator of the schools, we're one of the few, by the way, boards that regulate the schools and the licensees, one of the few industries that do that, is that it comes to us to have to deal with.
Yeah, I appreciate that. I just wanted to make sure we're all going to go forward if they accept this with the goal of working together and
right.
Make it happen.
Right.
Board Member O'Brien, I want to also point out that in nowhere did the recommendation state anything about citations or finding hairs and combs. It was strictly regarding bookkeeping and things of that nature. Okay. But also, Ms. Dixon, the board staff is wonderful. They're there as a resource for you. You now have a partnership. You're getting what you've been asking for. So I hope you see that and you can utilize that. And if you do have questions, that they become addressed before they become the issue that your lawyer was just trying to bring up to avoid. You know what I mean? So if you're unsure about something, they're always there to help you. They're a great resource. They want to see you succeed, and I hope that comes through with this recommendation rather than the revocation. Okay.
Madam Chair, one last sentence here. I do want to reiterate for the record that we are here to work with her to get her in compliance. That's what we're here for. We don't want to cite her. I'll say it again. We don't want to cite her. We're not in the citing business. But it's a tool that we have. Every board, every regulatory agency has it. Real estate agency, everybody, OSHA, they have that citing authority. You have to recognize that. But I don't think they like doing it. That's not what we're here for. We're here to get you in compliance. So the other thing is that, we're respectful. We got to be respectful to each other. Yeah. My staff is extremely respectful. It starts from the top. It starts from me. We're very respectful and professional. But it has to be reciprocated. It has to go both ways. We're not harassing. We don't do that. We don't have time to harass people.
And I would just ask if, I'm going to be getting on an airplane this afternoon, hopefully, and so I wouldn't be available for my client to talk to this afternoon. So I would ask that if the board adopts this recommendation, that the list that you required could it be due by close of business tomorrow, so that she has my availability to counsel with? Because I'm going to be on an airplane till all day, all the rest of the day.
It'll be in writing. It's also a matter of record. I know your record, the transcripts won't be ready yet. I'm sorry, Steve McDonald for the record. Sorry, Madam Chair, board members. Yes, I can have a bullet point listed for you, but it's of course on the record, so that's what we're going to stick with. If the board adopts it, that's really what it's really their vote. I don't have a vote here. It's really their vote. Thank you, Madam Chair.
Thank you. Board Member O'Brien, I just want to point out that it does look like we lost Board Member Douglas. Since we did put that on the record with Board Member Moreno, we're going to do that as well. I'm not seeing her up there. So on the record, 103, it looks like she lost connection. But we still have a quorum. So if everyone, yeah? Ready for a vote? Motion? Huh? Yeah.
You guys are good with all the recommendations?
Yeah.
Yes.
Okay.
Yeah.
Board Member Detry, yes.
Oh, and Board Member Wogutsa, I have one more question for staff. I'm sure, I don't know if this is something you have to coordinate with Denise. At what time would she need to have the other programs removed? Once the final students complete, or what is that looking like? I'm sorry? What is that looking like? Sorry.
We'll let Janie Huggins answer that on your question. Member Wolf.
This is Janie Huggins for the record. The board order won't go into effect today, but we are asking as part of this recommendation for a list of all of the students that are currently enrolled in the program as of today. It will be due end of day today. There should be no new enrollments per this recommendation for any of the other programs to allow a proper teach out for the existing students that would be in programs that are not going to be moved forward.
Okay.
Board Member O'Brien, are you asking the board to choose option 1 or 2, or are you leaving that up to Ms. Dixon to choose?
Madam Chair, Steve McDonald for the record. Actually, it was, we were looking at, of course, you're the ultimate decision here. It's your vote. But we were going to give grace to Ms. Dixon to make that decision if she wants to keep the full-blown program of cosmetology,
absolutely.
or go to the smaller programs and do that combination. And then, of course, if the board members want to allow that and to give her time to make that decision, that's the board's call. Or you could say, make a decision today, or the board can say, I'm going to make the decision. It's your vote to allow her to do what she wants to do. It's a privilege to have this license. It's not an automatic, right? Mm-hmm. It's like a lawyer. It's a privilege to have a lawyer license. Mm-hmm. You don't just get it.
She's going to pull the students.
Moral character, all kinds of things you've got to do.
Yeah.
So.
Yeah.
Yeah.
Board Member O'Brien, I think as far as that recommendation portion goes, we will leave the decision up to Ms. Dixon. It is her business. She should have the right to choose what she is going to offer to the students to come into her school. However, we do need a decision for that by end of day after you pull up your students and feel where everybody kind of sits in, what's your most popular programs. You should be able to determine what you want to do going forward. And then Board Member O'Brien for board staff. If Ms. Dixon chooses to add on, let's say she finishes her probation period, everything is, she's operating as a normal school again, blah, 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 will she be able to add on AE if she comes before us and asks for a variance?
Yes. Madam Chair, if you could talk for the record, yes.
Okay.
I mean, that'll be, if she meets all the conditions of the probation.
Okay.
Or even prior to that, of course, we recommend that you meet the probationary period first.
Right.
But that doesn't prevent her from trying to add programs on.
Okay, great.
She doesn't have to just come to the board, to board staff, we process it like we normally would.
Yeah.
And then if we had questions, she would freely answer that and give us the information. And if we couldn't do it administratively, we would bring it to the board for the board to vote to grant her that.
Very good. Yes. Okay, good.
And then one more thing, Board Member Wold. As far as the registrar goes, do we have a time frame? We want a new registrar, and because it says designated registrar, not school owner or instructor, preferably.
Yes, Madam Chair. Board Member Walt, Steve McDonald for the record. Actually, through testimony, I think she already said that she has a registrar, that she's already training a registrar to take on that position. It's just part of the conditions that we had already drafted.
Is that person an instructor or no?
I'm sorry, what was your question?
Board Member Wood, is the person an instructor the new registrar? No? Okay.
No, it's a separate position.
Okay.
Because, we deal with the registrar so much. That's why we need to have a separate person.
Okay.
Okay. Board Member O'Brien, for the record, it does look like we lost Board Member Harris as well. 108. So just putting that on the record for others. We have a quorum.
Jeffers.
Yeah. All right,
I'm still here, but I have to leave. I have to leave at 1:30. I have to.
Do you
leave.
have any questions?
No questions.
Okay, then we can make.
Yes.
Okay. How do we do this?
Yeah, how do we do this? Jeez.
Senior Dag Todd Weiss, the board can we can make a motion to order discipline consistent with recommendations of board staff. The only thing we would need to add is I know there was a request to allow leave for board counsel to file a motion for attorney's fees and costs. We need to set a deadline for him to do so if the board is going to grant him leave to do that. Probably within the next few weeks, since we have a meeting coming up in July. That's the only thing I would, deadlines for filing of a motion for attorney's fees and costs.
When would you like your deadline?
First Friday of June would be awesome.
Okay. All right.
Friday the 5th.
Friday the 5th. Okay, thank you. Board Member O'Brien, I'd like to make a motion to adopt the board staff's recommendation for discipline. I would also like to add in that we will need to make a motion regarding a future date of June 5th deadline for attorney's fees. Actually, that's not right.
No, I mean,
No.
so the,
Why don't I do the motion separately?
Okay.
I'll do the motion. Do you want me to, or do you want to do this one?
I want to put it with the
Okay,
disciplinary
sorry.
order. No, that's okay. So it'd just be.
Hold on. Okay.
So it's a grant of leave for board counsel to file a motion for attorney's fees and costs due by June 5th, 2026.
Grant of leave for board counsel to.
What are you requesting?
A copy of his all the conditions.
Can you put, so she wants, you want it to do by the end of the day? Is that
Well, I'm just saying, if she, I didn't write all that down, I stopped.
Understood.
So he said he has copies of that, if he can make sure to circulate those, so she can work on.
I will email you a copy within 24 hours
Perfect, thank you so much.
with my client's permission. And I'll add the motion for leave too.
Okay, perfect.
Yeah.
Okay, new motion. I would like to make a motion to adopt the board staff's recommendation for discipline for this case, and I would also like to grant a leave for board counsel to make a motion of attorney's fees and costs that will be due by June 5th. Can I have a second?
Board Member Douglas, I second the motion.
She's back.
Oh. Yeah.
Yeah, my phone died.
Oh, they're both here.
For the record, Board Member Douglas and Harris are back on the call. And we do have a second on the floor. So all in favor?
Aye.
Aye. Aye. Any opposed? All right, motion carries. Okay.
Okay, can I just ask for clarification? What do you need? Do you need something by 5 o'clock today?
Yes, we need the list of students that are currently enrolled.
And who do you want that sent to?
And we need also the decision if she's going with option 1 or option 2. If she's going to do option 1, which is cosmetology program, or if she's doing option 2, which is aesthetics and nails. And she should submit that by 5 o'clock p.m. today to Janie? Inspection.
To Jamie. Okay. 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 And then before this is implemented, we'll have a copy of this so that she can work on implementing it. 24 hours.
I'm working on it.
Okay. Okay. Thank you very much.
Thank you.
Appreciate your time.
Okay, good luck.
Yeah.
And thank you for telling us more about what you did. That changed a lot.
Board
you.
Member Walt, I hope that you are able to make these changes, and the next time we see you, hopefully it's not this, and it's something positive.
A tour of the school.
Yes, definitely we'll have to come check it out.
All right, moving forward with agenda item 5, which is comments from the general public for discussion only. The board will entertain comments from the general public for any item that is related to the Nevada State Board of Cosmetology. Members of the public can call into the meeting to make public comments by dialing 1-720-707-2699 and entering 897-2923-6029 for the webinar ID. Comments are limited to 3 minutes or less, and no action or discussion can be taken during public comment. Do we have any public comment at this time? Okay.
Bye. Thank you.
I'm not seeing any hands for public comments, so let's move on to comments from board members for discussion only. The board will entertain comments from board members for any item that is or is not on the published agenda and is related to the Nevada State Board of Cosmetology. No action can be taken on a matter unless it is included on an agenda. Comments should be limited to 3 minutes or less. Board members, do we have any comments?
Thank you, everybody. that was exciting as far as just the hearings and just the way you guys carried yourself, Janie, Lauren, Mr. McDonald, Mr. Wise, Joseph, and the court reporters. So that was a lot. I think we've heard that a lot, and I'm just grateful that I have really awesome support and resources here. And thank you guys for being so flexible and just continuing to give to our community, everyone online. This is probably the best board, and they're here to, like I said, stay in compliance. We don't want to cause anybody extra stress or harm, but just don't put yourself in that position. So thank you guys so much.
Thank you. All right.
Board Member Douglas, I agree.
Thank you.
Madam Chair, if I
Yes.
may interject here.
Yeah.
Steve McDonald, for the record, I want to say thank you. Board members, I guess I'm biased. I think I have the best board amongst all the boards that we have in the state of Nevada, which we have, over 30 of them or more. I still think that ours is the best. So I really appreciate all the hard work and everything that we give you. That document that you see takes a lot of work to put together and a lot of your time to review. So I want to say thank you. Thank you to the AG's office, Mr. Wise. Thank you to our Deputy AG, Mr. Estunio. And of course, thank you to my very supportive staff statewide. They do a great job for me. So I really appreciate you all.
Thank you.
Thank you. All right, everybody, we are going to call for adjournment. It is 1:16 p.m. on May 11th, 2026. Thank you, everyone, for your time, and we wish you the best week. Thank you.
Bye-bye.
Thank you. Bye.